Good morning, all. This trial is in the matter of CFI 009-2024 and is being held by way of video conferencing before Her Excellency Justice Sapna Jhangiani, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Stevenson Harwood Middle East LLP. Lead counsel is Mr. James Smith. The defendant is represented by Davidson & Co. and lead counsel is Mr. Stephen Docherty. Thank you, Your Honour.
Thank you, Registry. Did you want to mention that we have a work experience student observing today's proceedings, just so everyone knows that?
Yes, of course, Your Honour. So the registry would like to inform both parties that there will be an intern here working with Her Excellency. So if anyone has any objections, to please say so.
Is that fine with everybody?
Absolutely.
Thank you. Right. I know we have a trial timetable and we start with housekeeping. I just want to raise, I know we had discussed at the pre-trial review that we would actually start the trial every day at 8 a.m. And I think there was a mix-up and that wasn't noted by the registry. But I do think we have a lot to get through, and I think it's really important that we're as efficient as we can be with the timing. So I would like to direct that we will be starting at 8 a.m. UK time, which I understand is 11 a.m. UAE time for tomorrow and Wednesday. And I'm mentioning this now so that it can be noted by the registry, and if necessary, updated links to the hearing for Tuesday and Wednesday can be circulated. Can I just confirm that the registry have noted that?
Yes, thank you, Your Honour.
Thank you very much indeed. I should also mention that I have just received a supplementary bundle of documents and also a joint bundle of authority. So thank you very much for that, and thank you also for the trial bundle. Is there anything else we need to mention by way of housekeeping? Why don't we start with Claimant's Counsel?
I'm grateful, Your Honour. Now, I was actually going to begin on the question of bundles. The court should have, first of all, a trial bundle. Now, as to that bundle, there was discussion at the last hearing of the relationship between the page number in the bottom right and the PDF page number. The answer is it is plus 15. In other words, if you're directed to page 100 of the bundle, the manual page number is 115. I should mention that there are a series of links at the start of the bundle, and those all take you straight to the correct document.
That's very helpful. I should mention, I actually find bookmarks very helpful, so I tend to navigate through the document through the documents by way of the bookmarks. Yeah. But I note that the defendant in the defendant's skeleton argument refers to page numbers. That is a bit more difficult for me, but I will manage. But perhaps when we have oral opening and closing submissions, we'll have screen sharing in any event, but tab numbers would be helpful for me.
I'm grateful. The bookmarks, the electronic bookmarks work, by the way, or at least they did the last time I tried. The court should have an authorities bundle. That is definitely best navigated electronically. The court should also have a draft order following the PTR that was sent.
I do not recall seeing a draft order, but I may be...
It was only sent on Friday, so it may be best if I go through that. In terms of other matters, the start time of 8 a.m. is noted, and from our end, the one point, I've just received something from the registry. I hope, well, as we're all on this link, it can't be the wrong link. The question that I should address briefly is, during the course of witness examination, we do have a supplemental bundle of documents. Axiomatically, the documents in that were not in the bundle at the time when witness statements were being finalised. I envisage 3 or 4 supplemental questions to the claimant on those documents, but not beyond that. And I'm sure that my learned friend may be in a similar boat. Well, he may be. In terms of the outstanding matters, if I may say so, from the PTR, there are a few of them. The court will recall that there was quite extensive discussion of production at the PTR, and I think it may be best if I begin. I'm trying to avoid being too contentious and just being narrative about that. My learned friend will correct me, and we will, if necessary, argue these points. Essentially, what happened after the PTR were 2 things. Some supplemental production was produced by the defendant, and that is in the bundle, the supplemental bundle. And the claimant produced supplemental production. You'll recall, Your Honour, there was discussion of searches that had been interrupted pending a reply from an email from the claimant's solicitors about production and various responsive documents potentially available. Now, the position is that they were several hundred pages were provided to the defendant last week on, I believe, Tuesday. The claimant's position was and is that the overwhelming majority of those are simply not relevant to the issues. The defendant then selected the documents it wanted in the supplemental bundle, and those documents are in the supplemental bundle, and that is where that stands. In terms of the document production statement that the claimant was going to produce, there has been a degree of correspondence about that, and I'll take it quite shortly. As of last Wednesday, we were asked to provide a draft document production statement. We did that on Friday, and the claimant is prepared to sign that statement. Now, I understand literally just before this hearing, literally minutes before, I understand that the defendant's view is we should simply be signing and serving that. So my understanding, which I have to say is 10 minutes old, is that is what is going to be done.
Right, and presumably you'll do that as soon as possible before the claimant gives evidence.
I was about to say that. And now my understanding is that the claimant is in the office of my instructing solicitors, so it should be not beyond practical possibility simply to sign and return that statement. So that is where we are on production. In terms of the draft order, it may be best if I simply, I'm slightly reluctant to screen share, but I remember Your Honour saying that Your Honour is very used to screen sharing, so I apologise if I produced the wrong material. Hopefully not.
Fine. I should mention, unfortunately, I have technical challenges and I don't think my email is working properly since Friday. So I'm just checking if I've received a draft order. I haven't. It may be on the portal, but I mean, at any rate, I haven't seen it. It's a draft agreed order, is it?
No.
Right.
That's I believe the defendant's position is that there's no need for an order at all after the PTR. I have to say I found that it would be for the defendant to explain it. I found it slightly surprising. I would have thought that there were matters that the court made rulings on at the PTR, which should be recorded in an order. So let me just try and find the draft PTR order. And I'm going to share this with the screen, and my apologies if there is any technical glitch. And I think the easiest thing, what I'm planning to do, is just simply to take Your Honour through the order paragraph by paragraph, if I may.
Certainly. Is it possible, again, I'm very conscious of time and how much we have to get through in terms of this hearing. Is it possible that we could, if you feel it's important, and I don't have a view on this because I haven't seen the order, but that we can record everything within whatever decision is made following this trial so that there's a record of it? I'm just concerned that we may spend a lot of time going through this order when the priority is the trial.
Your Honour, I very much take that point. I think in deference to the position raised, by the defendant, I did feel it incumbent on me to say that. The short position here, the relevant provisions are those of which I am screenshotting now. Can I go straight away to paragraphs 5 and 6, because I think these are important issues which will have a bearing on the conduct of the trial. Yes. Now, my understanding, which is shared by those instructing, was that the court had ruled that witnesses should not be present during the testimony of other witnesses until they finished their own testimony. Now, that is what is recorded here at paragraphs 5, 6, and 7 of the order, and those are matters I draw to your attention. The rest of it, for example, costs in the case, liberty to apply, I'm not wasting your time with, Your Honour, but those are orders which reflect our understanding of the ruling the court had made. Now, in terms of one other matter which the court addressed, but from my recollection did not make an order about, this was about what I might call the witness protocol. And so at paragraph 10, we've simply recorded what the court said about its expectation, but it's not an order. So the bit that is relevant is paragraphs 5 through to 7 of the order, and we consider those to reflect and provide a workable way through the practical question of witnesses not being present during the testimony of other witnesses. That is all I have to say about that. For what it is worth, I should mention that the wording taken is borrowed with gratitude from an order made by Justice Martin in the Mahmood case, and I'm sharing that now. This contained the judge's reasoning as well, but you will see, Your Honour, that at paragraphs, if this is too small, shall I enlarge it, or hopefully it's very similar to the order that's proposed here. So those are our expectations. In terms of other matters, I'm conscious of time and the need to get on with opening. So hopefully my screen share has now ended, and I will pass over to Your Honour.
Thank you. That's most helpful. And I do think that having some degree of detail as to what it means to have sequestration of witnesses, as you've set out in the draft order, is very helpful. Let's hear from the Defendant's Counsel in response to all the housekeeping points that you have raised.
Yes, thank you, Your Honour. Perhaps if I just deal with the draft order first of all. Really, I think the setting aside the point of difference on form and on what's necessary, on the point of substance, just to cut through it, I think really it's paragraphs 5 and paragraph 10 where there's a difference between the parties. The first point really is that when it comes to sequestration, recollections, I think, differ. I don't recall it being discussed that witnesses would be released to attend each other's evidence after providing evidence. And you'll recall that at the PTR, the defendant's position was that parties should be able to attend throughout for various reasons, including ability to give instructions. This is the defendant in a slightly difficult position in that the claimant will provide evidence and be free to provide instructions to his solicitors throughout the defendant's witnesses' evidence, which is a luxury simply not afforded to the defendant in these proceedings. We won't be able to seek any instructions from Mr. Velici, who will have had first-hand experience of some of these interactions, whilst the claimant gives evidence. And that, we say, poses an equality of arms issue, effectively. The claimant is going to be able to do something that we're not, and that's a consequence of the claimant having sought sequestration in the first place. And so we take the position that if witnesses aren't attending during evidence, that should apply equally across the board.
This wasn't raised at the PTR. We did discuss whether witnesses should be sequestered. We discussed it. I heard submissions and I gave my view that that would be my preference. But I do not recall any discussion about whether a witness who was also giving instructions and whether there should be a carve out for that. So that's the only issue of contention here. Is that correct? So the claimant is contending that as a claimant as a witness, but also giving instructions, he should be allowed to attend the evidence of the other witnesses. Is that what the issue is here?
Yeah. I think the issue of what wasn't discussed is the releasing of witnesses after they provided evidence. We had understood that the order reflected is if witnesses aren't attending during each other's evidence, that should just apply across the board.
But what's the issue if he's already given evidence? If his evidence has already been given, the defendant's concerned that the claimant shouldn't be available to observe the evidence of the defendant's witness. Is that correct?
The issue is that it gives rise to a scenario in which the instructing party on both sides, or on one side, is able to attend during cross-examination of the other party's witnesses, whereas from the defendant's perspective, it won't have that ability.
But the whole point of the sequestration is just to protect the evidence. And if the claimant has already given evidence, again, I'm so sorry if I'm missing something. I'm not sure I'm fully on board with what the defendant's concern is.
Well, I think I've articulated the concern. Really, it was a matter of flagging a point that we don't think had been addressed at the PTR. Obviously, it was going to be for Your Honour, and if Your Honour has a view on that, that's fine. I'm flagging an issue that had been in the form of order was going to be that the claimant attend, but the defendant not, once he's provided cross-examination. It's a point we would have raised. As I say, that's the point of substance number one. I take Your Honour's view is that once a witness is released, a witness is released, and it may well be that that's where your landing is on it, but that's what the defendant's point of difference as to our recollection of the PTR is, which I flag. And point of difference number two relates to the form of words provided at paragraph 10 of the draft order, which relates to where witnesses are attending from and who's going to be present during their evidence. It seems to be presented in what has been submitted to the court in a form of words that suggests that is what the protocol is going to be. I don't recall it at the PTR being discussed in those terms. It was if someone wishes to have a solicitor in the room to assist with the bundle, that's okay, but that was not, in my understanding, a requirement.
Right. Would it be possible that we could please pull up again paragraphs 5 and 10 and just see if we can resolve the issue on paragraph 10 and come to a landing, because we will be hearing from the first witness fairly shortly, and I want to make sure that we are all agreed on what the provision is. So the court's expectation is that witness, just give me a moment. Right. And Mr. Doherty, am I correct in understanding that the defendant's position is it may not be necessary for a witness to have another person in the room? I think from what I understand you're saying, we had discussed at the PTR the possibility of having a solicitor in the room, but it's not necessary for another person to be there. Is that correct? Was that a yes?
Yes, sorry, that was my understanding.
Right. So, Dr. Bickford-Smith, can we resolve this?
If we, my position, I think we may be at cross purposes, Mr. Doherty and I. If a witness wants to give evidence on their own, I'm not planning to object to that. Quite obviously not. It was about what happens if they were giving evidence in a room with other people. That was the point.
Right. Okay. Because I think what we're going to do to proceed as quickly as possible. Any directions that I'm handing down about these provisions that we're talking about now will simply be included in the decision that will follow after this hearing, and the wording will just need to be amended that a witness doesn't have to have another person in the room, but if they do, if you could just amend it. Yes. Isn't the real issue, it doesn't really matter who they have in the room or whether they have anyone in the room, but they should not have their own notes or documents. Is that the issue? Is that the most important thing to record?
Right. I think that's not an issue. I think we just wanted to be clear that there was no prescribed form. As long as they're giving evidence on their own, that's sufficient.
Yes.
And then on the point of substance, I take Your Honour's view that once a witness is released, they're released. I think there is still, I suppose, a foreseeable chance of things arising during the course of cross-examination on which the defendant would need to take instructions. And really, it might be a question about what the full extent of sequestration is in those circumstances. Now, the defendant's witnesses are not going to be in attendance while the claimant provides evidence. If there are points arising on questions of fact on which instructions need to be taken, it may well be that it might not need to be a carve-out, but that there ought to be some understanding that the defendant's counsel are not going to be prevented from taking instructions, albeit without reciting to those witnesses the form and content of what was actually said during cross-examination.
I think that's fair. I mean, ultimately, I want to make sure that there isn't any unfairness by proceeding with the sequestration of witnesses. Can we please scroll up to paragraph 5? Because I think that's what you mentioned specifically.
Can I check that my screen share is working?
Yes, it's working.
So I've to cut to the chase, I've simply added at 6.5 liberty to apply for leave to take instructions. I appreciate that's brief, but it I'm
not sure that covers it. I'm not quite sure that addresses it, because what I understand Mr. Doherty to be saying is that it may be that in the course of evidence being given, instructions would need to be sought. And I think under this formulation, on each occasion, leave would have to be applied for. But I don't want to speak. Again, I'm just trying to ensure that we have a fair procedure. Mr. Doherty, I don't want to speak on your behalf. Does this address it? And can we also scroll up to paragraph 5, because that was the provision you specifically mentioned?
So, well, it was paragraph 5.
Yes.
I think if that's germane as it is, really it's the adjustment to paragraph 6.
Right.
I think I'd probably take objection to it being liberty to apply, because I can see that being cumbersome and so on. I think if it's liberty to counsel and solicitors to take instructions, that probably does cover it. And it's, of course, on the understanding that it's not going to be, dealing with sections of a transcript or repeating verbatim what has been said. It's a matter of taking instructions on things arising.
I appreciate that, and I appreciate that confirmation. Can we live with this, Dr. Bickford-Smith,
Yes.
as you've drafted it?
I've kept it as simple as possible. I've simply said it's a general liberty to counsel and solicitors to take instructions, and I hope that resolves the concerns raised.
Yes, I believe that's that's sufficient from my perspective. In terms of other housekeeping points that were addressed, Your Honour, I think one in respect of bookmarks, when I was preparing the skeleton argument, I didn't have the slightly different version of the bundle, which was bookmarked with the 15-page difference. So there will be some differences in the PDF numbering. I will address it as I go on, but it also, I'm afraid, means that I don't have the bookmark references. So I'll largely be dealing on page references during the course of today. What I'll do is I'll provide both the PDF number and the overall page number, so that it's clear what I'm referring to. And in any event, as we say, we'll make use of screen sharing to cover that. But I suspect what might assist Your Honour is if later during the course of the week I could provide you happily with an updated version of my skeleton, which includes the updated page references, if that will assist at the end of trial. And I can provide the tab references and the bookmark references in that.
Yes, tab numbers would be helpful, thank you. And I think we'll manage absolutely fine now that we know that there's a 15-page difference, but also since we have the screen sharing, we can all make sure that we are literally on the same page. So I don't think it'll be an issue.
Thank you.
Right, are we all...
Yes,
anything
there's
else in housekeeping?
Sorry,
yes.
On the issue of skeleton arguments, I apologise if this is a rather footling point, but at paragraph 81 of our skeleton argument, I don't need to take your honour there. There is a reference in the second line. There are reference to two cases, one called Dootson, Dootson, and the other being to Senews Limited. The reference to Senews Limited is an error and should be treated as deleted.
Ah, okay.
So it is simply Dootson v Stoves Limited. The following reference should be deleted. It is in error.
What paragraph number is that?
81.
81, right. Okay. And one housekeeping point from me. Could I please have a copy of the agreed case memorandum and agreed list of issues in Word? I assume the claimant prepared the first draft. I only have them in PDF, but it would be helpful to have them in Word.
My recollection is that they ended up as agreed documents, so they should have been submitted by, I believe, the claimant with the CMC documents, and therefore they will be provided in Word to the court.
Thank you very much. That's most helpful. Is there anything else before we move to opening submissions?
Sorry, I'm just receiving various. I hope that what I've said about the order, the case memorandum, I don't see it as problematic. My apologies. I think that's
you can
fine.
let me know about that later. That's fine.
Yes.
If there is any issue, you can let me know by closing submissions. That's absolutely fine.
There's one
yes.
final housekeeping matter I raise. I don't believe it makes a significant overall difference, but it is a simple point I mention. We had quite a long discussion about the trial timetable, and I must confess to having multiple versions of this, but there is just one significant point. Accepting very much what has been said about equality of arms, I flag this point. The more that I look at the issues in the case, and the more I consider matters, the more it seems to me that it would be preferable for me to move half an hour of my time, if I may, from my closing submissions to my reply closing submissions. And the reason for that is having regard to the way the defendant is putting its case. It seems to me that in many respects, the greatest assistance I can give the court will be in replying to the defendant's closing submissions, and therefore I would suggest that shift. Now, whether that means that my learned friend wants a brief further time to give a rejoinder orally, I simply mention it now as to the efficient use of time, because I am concerned that I'm going to spend quite a lot of time doing an oral closing. We're then going to have points raised by the defendant to which I'm going to want to reply. Obviously, I'm assisted to a degree by the way they're put in the skeleton argument, but it may be that they come to be put more fully in closing, and therefore can I simply flag that to the court?
Certainly. In principle, would there be any objection to that, Mr. Doherty?
No, I think as long as in principle the parties are using or spending their time in submissions broadly equally, that's fine. I mean, I'd always have to reserve my position insofar as anything new came up in reply that hasn't yet been vented, but one would hope that by the end of day 3, you're going to have a reasonably full picture of what both parties' positions are on the main legal issues.
Thank you. Wonderful. I think we should be in a position now then to have the claimant's opening.
I'm grateful, and Your Honour should have, sorry, just one loose end, and with apologies to everyone. I am focusing now on simply giving my opening. I am conscious that there is a document production statement which has been promised to the court.
Yes.
I'm not going to sort of monitor my messages to confirm when that has been sent or not. I'm just proceeding on the basis that if there is a problem arising, I will inform the court of it in due course. So if
I understand that. What I think we should do is have the oral opening of the claimant, the oral opening of the defendant, then let's adjourn for 5 to 10 minutes. Let's make sure that the document production statement has been issued and shared by the claimant and the defendant is happy with that, and that everything's in order before we move to the claimant's evidence. Does that sound sensible?
I'm grateful for that, Your Honour.
Yes.
It does.
Wonderful.
Now, beginning with my opening, the final housekeeping point I raised about the timings for closings and reply closings dovetails into my opening submission, because my opening submission is a straightforward one. This is a case arising from a straightforward and serious failure by the defendant to meet its obligations to the claimant, and the ensuing claims, which I'll discuss further, are in my submission, as a matter of both law and practice, straightforward claims. They are claims by the claimants for his dues, DUES. There are also, as a matter of law, claims that arise with respect to dues, DEWS. And there are claims arising from his termination of his employment for cause. But if I can be entirely straightforward about this, this is the kind of claim that the SCT is used to dealing with week in, week out on a fairly large scale. Now, what has complicated this case are two things. The first is that by virtue of its quantum, it has to be issued in the CFI. But the second and main point here is that we have been faced, in answer to this claim, with the erection of a series of hurdles which have turned this case from a straightforward run from A to B into a sort of Olympic hurdles contest. So what I'm going to do, if I may, is I think there is, of course, a risk of me spending all my time talking about the hurdles. There is a risk of the court spending its time sort of measuring the hurdles, considering each of them. Let's just begin with the salient facts. Many of these are not contentious. Some of them are very contentious. again, it seems to me obvious that the issue for the court in hearing evidence should be to focus on the contentious ones. So the basic facts are straightforward, and I'm not going to sort of repeat what's in my skeleton in detail. And most of the references I'm going to give are simply going to be references for Your Honour's note. So what we have here is someone who's experienced in financial services, who starts with an employer on a fixed-term contract. That is initially a 2-year fixed term. Again, there is nothing remotely unusual about that. That business then transfers its workforce to the defendant. Again, possibly slightly less usual, but far from unusual. There are no difficulties in law arising. It's worth remembering, and I'll just give the reference for Your Honour's note. Trial Bundle 387. We see, and I apologize if I'm not going to do a screen share of this because I'll probably end up sharing the draft order. But if I just go to Trial Bundle 387, which corresponds with 402 of the PDF, there's a line across part of the copy, but what we see 3 paragraphs up from the end there. This is on page bundle 387 PDF 402. You have been made aware we are in the process of winding down the representative office, and your employment will be taken over by Banyan Tree Asset Management Limited as and when it's duly authorised by the DFSA. There's also a visa transfer record which has survived, that for Your Honour's notice of 400 to 406. And then there is, for good measure, a company resolution concerning the transfer. That's a 397 to 398. And what we have as a matter of practice is the claimant working in what is a relatively small and tight-knit banking business where everyone does a bit of everything. He does well. He receives a salary increase. That's covered in some detail in the skeleton arguments. I don't really see how contentious it should be. And what certainly shouldn't be contentious is that he's promoted to be the SEO in February 2020. And if I can just give a bundle reference there, one will see it is at bundle 453 PDF 468. Now, we see various characters in this case introduced there. So at the top of 468, we see an email from the claimant to Mr. Aslam, who was working for Unitas, who were an outsourced corporate governance provider, effectively. Mr. Aslam gives evidence about his performance of some of the DFSA mandated roles, but below it we see the DFSA approval of the claimant as an authorised individual, and we can see the following licence functions: SEO and senior manager. Now, this is an important moment, Your Honour, for several reasons. I mean, first of all, to state the obvious, it's a promotion. But secondly, it introduces the claimant into a role that he will play in law until August 2023. Now, why do I say in law? And this, the reason for this lies in the DFSA and its regulations. Now, I appreciate that there can be a tendency to see financial regulation as a rather obscure area. But in this case, the financial regulations are a very important part of the factual matrix to this case. And I'll say a little bit more about them shortly. But just focusing on this email, the position is that having an SEO is mandatory. It is a mandatory function, and a regulated business has to have one. And the second and obvious point is that once one is registered at the DFSA as SEO, so one remains. And to remove an SEO requires a notification to the DFSA. And one aside, which is quite an important aside, is that following the PTR, we have finally had through the defendant's form of August 2023, terminating or seeking to withdraw him as SEO for the DFSA. Now, and I'll come back to that later. Now, a number of other things follow from this. The first is that we say it is obvious that the SEO of a financial regulated financial business is very unlikely to be a fixed-term employee. Now,
sorry, I was confused about that submission in your skeleton. So I look forward to hearing your explanation on that.
Yes, well, the short point is this. The first point is that, as a matter of fact, when the renewal date, the putative renewal date comes up in 2020, there is zero evidence of anyone saying, oh, we need to renew this contract. Here's a new fixed term contract. There is simply zero evidence of that. So the parties, it seems to me, have themselves evidenced what their understanding and agreement was. But secondly, and crucially, if the contract had lapsed, as in if it had not been renewed, the defendant would immediately have been in regulatory breach with the DFSA. And the reason for that is that there are various routes to being SEO, but the route that they had adopted at the time was that the claimant was a senior manager, and a senior manager has to be an employee. Now, a senior manager has to be various things, but crucially, at the material time, an employee. So had the claimant's employment lapsed, there would have been an immediate regulatory breach.
But what I find, the part I find difficult to follow is not that his employment continued or was renewed, but that the contract moved to a permanent contract rather than a fixed term contract. That's the part that I'm struggling to understand, why his appointment as SEO would lead to that consequence. I understand your point that it was renewed, and if he was not renewed, there'd be regulatory issues, and it just seems de facto, if we look at all the evidence, that he continued to be employed. But what I don't understand is why the contract would convert to a permanent contract.
I'm grateful for your honest question, because this allows me to clarify three things. The first is, it is not our case that as a matter of law, it followed that by being appointed as SEO, the employment contract became permanent. It's a matter of evidence. Yeah.
Yes.
That's point number one. Point number two, what we say on the facts is, the question is, in saying that one can see the contract is being renewed, one is drawing a conclusion from the facts about what must, as a matter of law, have happened. And what we say is that the correct conclusion from the facts and from the context, including materially the fact that neither in 2020 nor in 2022 was there any discussion of renewal at all. What we say is that the correct conclusion on the facts is that the parties were proceeding on the basis and had agreed that the employment would become permanent. And I can take your honour in closing to various bits of evidence which suggest an appreciation of permanence, but I don't want to make a false promise here, in the sense that I don't want to say to your honour that there is some email or document where someone says, congratulations, you're permanent. It's a question that needs to be answered by reference to the full facts and matters, which is why I was planning to deal with it only briefly in opening, but I am actually grateful to deal with it in more detail. Whilst I'm on this, the third point, which is really quite important, is that there are various DFSA rules which are referred to. One of the other potential routes into an authorised function is to be a director. Now, one of the important points to draw, and it's a fairly elementary corporate governance distinction, is between an executive and a non-executive director. Now, the question of employment status will obviously depend on the facts of the case, But there is, unsurprisingly, there is no rule of law that a director should not be an employee. The question is whether the director is an employee. So that is what we say happened, but that will be a matter for evidence, will be a matter for the court to reach its own conclusions on.
And I'm so sorry, I just have one more question, and then I promise
Yes.
not to interrupt and let you go with your flow. But again, because there's so many issues and sub-issues in this case, I want to understand that I have the correct framework of what a decision on various issues will lead to. And if the court were to find that there was a renewal of a fixed term contract from 2020 to 2022, what is the impact of that on the claimant's claim? And particularly, I think I understand correctly that the defendant's position is that if there was a fixed term contract that ended in June 2022, and let's say that there was another 2-year fixed term contract commenced after that, then all dues would have to be treated as determined at the expiry of the contract in 2022. Is that correct?
It is correct that is the defendant's position. It is not correct, we say, that is simply not right in law. And there's a case relied on by my learned friend, and I will have to address this in closing. But I simply make this point. Apologies for being possibly deeper into the law than I had wanted to get so quickly, but I do think it's an important question, again, the court has raised. What we say is that in these circumstances, there would be continuous employment, because where there are a series of renewed fixed term contracts, we say that the court should proceed on the basis of continuous employment. And one of the reasons for that is that, yes, it's true that in many legal systems that we have employment law, there are statutory provisions about continuous employment, but it is possible to have continuous employment at common law, albeit that because of the statute it isn't concerned. But what we say, if I may say so, and this is quite an important point to make, the suggestion that this fixed term somehow draws a line in the sand as at June 2022, and then you would, on the defendant's argument, you would read through 6 months later after that and say any claim before that is out of time. We say that this is, if I may say so, a hurdle that again does not work, and it doesn't work first because there's continuity. But secondly, and very importantly, and this is an issue that I was going to address, but I'll take it now and out of turn. We say that the real impact of this, even if the court, I hope not, is against me, one, on whether there were fixed term contracts, two, even if the court were to say no, there was no permanent employment, no, there were 2 fixed terms. Yes, the effect of the fixed term is that the claim would have had, that aspect of the claim would have had to be brought in February 2023. That is not the end of the matter, because what it would be the end of, potentially, subject to arguments about Article 20, which I fear if I get into Article 20, this closing is not going to end anytime soon. But subject to arguments about Article 20, where it would leave the claimant, is that in practice, is that he would be unable to obtain penalty under the penalty rules of Article 19 in respect of sums predating February 23. That's where it would in practice leave him. And that leads me into the next and important point. We say that might, subject to argument, be the end of a penalty claim, but it would not, and it might be pro tanto the end of a wages claim in respect of that period, but it would not be the end of a contractual claim. Because one of the key problems that we have in this case, and it is, I think, important to stand back here, the defendant is left arguing the position that an employee who enters into an employment contract is in a worse position than anyone else who enters into any other type of contract, because they have to bring a claim in respect of that contract, not within 6 years, but within 6 months. And we say that is wrong, and that the employment law supplements the rights available to the parties under other DIFC laws, such as the law of obligations, such as the law of contract. And so what would happen in our submission is not that there would be a puff of smoke and the pre-June 22 wages disappear. It would be that they could be claimed in and are claimed in contract, but would not, in this hypothesis, be eligible for penalty. So in other words, it's a very simple thing. It's sauce for the goose, sauce for the gander. If you are relying on the advantageous provisions of the wages law, so to state the obvious, the general law of contract does not impose a penalty equivalent to your daily wage for each day of non-payment. Now, if you are seeking to rely on those provisions and those beneficial positions in law, then you have a time limit, but you still have your general rights in contract. So that is where we are. I hope I've explained. I'm not, obviously, I'd be delighted if Your Honour agreed with my case immediately at once, but at least I hope I've explained it.
No, I understand your case. That's extremely helpful. And don't feel that you have to be cut off at 30 minutes, because I'm very conscious that my questions may have taken you away from the opening you were planning.
Without further ado, I'll go back to that. Now, it's uncontentious in this case that what happens here is that the defendant is dependent on Banyan Tree Bank in Mauritius. Banyan Tree Bank goes into conservatorship, and the practical question was what to do. And effectively, there were two options: winding up or selling the business. I'm taking it possibly slightly short because I do want to make up a little bit of time. Now, it's at this point again that the DFSA regulation comes to the fore, because the value of the defendant lies in significant part in its license. Its other value lies in having an infrastructure, including the claimant, including Unitas, so it's an up and running, functional, financial regulated business. And it's at this stage that Mr. Vellucci Enzo enters the frame. And what we now know from his evidence is that Unitas, who are performing the defendant's compliance function, introduce Mr. Vellucci Enzo to this as a possible, effectively, shortcut to a license. And it's important to say that Unitas play a driving role in this transaction. The court in evidence will be taken through this, but one can see that Unitas, for example, are in email contact answering detailed questions from Mr. Vellucci Enzo's lawyer. Now, a lot of the detail that transpires is irrelevant, and it's irrelevant because this is not an action to rescind the share and license purchase agreement known as the SPA, although I would mention the words "and license" in its title, which gives a bit of a clue as to what's going on here. And what we have is that in the course of this, they are asked directly about the number of employees, and what they are told in terms is that the claimant is there and what he's being paid. And we then have the SPA is concluded, and that occurred, just for your lordship's sorry, my apologies, your ladyship, no, your honour. On the 17th of June, we have the SPA. Now, crucially, it's the 17th of June, 2021. Now, the reason I mention that is that there is then a significant series of events that follow. I'm going to turn to those events in a moment because they are one path. What happens about the SPA, what happens with the regulator. But the crucial issue here is for my client's purposes, is that regular payment of his wages stops. And there is clear evidence of the claimant pursuing this with the then UBO. And just for your honour's note, this is 749 to 754 of the trial bundle. And not for the first time in this case, when the claimant sends an email about his wages, he gets very abruptly shut down. And that is, in my submission, one of the important things for the court to remember. Although the claimant is the SEO and the regulatory head of it, the simple fact is that when it comes to asking for and seeking payment of his wages, he's effectively having to take the begging bowl to the UBOs, and that happens both with Mr. Single and then later. Now,
sorry, on the page number, sorry, was that the PDF page number or the written number on the trial
it's the
bundle?
written.
Yes.
It's easier if I give the written number of TB 749 to 754 and then add 15 to it rather than the other way around.
Sure.
So that's one thing that's happening with the claimant's wages. The other thing that happens, and I have to say it's surprising how little evidence there is about aspects of this in this case. But anyway, the DFSA send a preliminary decision notice threatening to withdraw the license. Now, I think that is important enough for me to try screen sharing it. And let me try and do that. So here we are. I now can't see any of you, but I hope you can still see me. Now, here we have a preliminary decision notice. And what the DFSA is proposing to do, I'm just going to blow it up if I may a tiny bit. What the DFSA is proposing to do is to withdraw the license. Now, the catastrophic effects of that should be obvious. Another point I would make here is that the DFSA goes into considerable detail. It talks about the obligations of the concern of the firm. Can I just flag 7E there? Paragraph 7E on the page I'm screen sharing. Deal with the DFSA in an open and cooperative manner and keep the DFSA promptly informed of significant events or anything else relating to the firm of which the DFSA would reasonably expect to be notified. Now, one then sees a litany of failures, including failures to update the DFSA, etc. And one then sees a series of criticisms made. Now, I end the screen share there. The reason I mention this is that it underlines the point I've been making, that the regulatory issues in this case are not sort of simply things floating out there. They're very important. Now, what happens in short is that the claimant and Unitas, together with Mr. Singh, make representations to the DFSA. The DFSA ultimately agree not to withdraw the license, but they impose a series of conditions. And when it comes to approving the change of control, that's the change in the ultimate beneficial ownership, one sees that a key matter for the DFSA is whether the claimant is continuing in his role. And that is something that they are unequivocally told is the case. And the background the position that ensues is this. The DFSA want to know that the claimant is carrying on, but the claimant has got a significant amount of unpaid dues, DUES. If it's easier, I'll simply say that whenever I say dues, it is DUES unless I say something different. Now, the position, therefore, is that it would have been open to Mr. Vellucci, Enzo, and Mr. Single to say, well, we're not going to pay the claimant. This is all at an end. Let's scrap this transaction. Let's move on. But that is quite simply not what happens. And what instead happens, and these give rise to some really very confusing emails, are a series of negotiations about who's paying the claimant's dues. Now, I simply observe that as a matter of law, those were matters between the UBOs, past and putative, to resolve between themselves. And I'll take the court in due course in evidence to where the SPA says that the responsibility lies. But effectively what ensues is a rather complicated three-way series of communications. And in the course of these, the claimant provides a calculation. Now, this calculation is the document being leapt on as a settlement agreement. And what we say about this very simply is, first, the claimant never agreed to accept only the sums recorded in that document as a full and final settlement. It was a part payment. Secondly, he was providing this document at the request of parties involved in a commercial negotiation between themselves. Thirdly, there was no termination of the employment. There is no dismissal letter, a point that I underline. There is no dismissal letter. There is no settlement agreement. And in the DIFC, settlement agreements have to abide by the mandatory requirements of Article 11. Now, it may be helpful if I go to Article 11 just briefly. Here we are. This is it, just for everyone's reference. This is in the authorities bundle at page, and I believe in this case the PDF bundle references and the hard copy bundle mix up. Are correct. Sorry, equal 1044. So I'll just share it now. And what one sees here is 11.1, the requirements of this law are minimum requirements, and a provision in an agreement to waive any of those requirements except where expressly permitted under this law is void in all circumstances. And then we have the carve out for that. Nothing in this law precludes an employer from providing terms and conditions that are more favourable. That goes back to one of the arguments we've had already. And then subject to Article 66.13, which isn't material here, an employee from waiving any right, remedy, obligation, claim or action under this law by entering into a written agreement with their employer to terminate their employment or to resolve a dispute with their employer, provided, 1, the employee warrants in the written agreement that they were given an opportunity to receive independent legal advice from a legal practitioner as to the terms and effects of the written agreement, or the employer and employee took place in mediation proceedings provided by the court. So that is the simple position on this. And we say, we of course, we very firmly join issue as to the evidence. The court will be hearing heavy cross-examination on this topic, which I'm not going to preempt. My learned friend may not want to preempt either. But what we say is its legal relevance is questionable, given the provision that I have just taken the court to. Then what happens as a matter of fact, and I will take the remainder of this very briefly indeed. What happens as a matter of fact is that the claimant goes on working. Now, there is an extraordinary controversy about this. I have to say, this would be a matter for closing, but any suggestion that what the claimant should have been doing was sort of going out there, being a dynamic figure, or building some huge book of business in the DIFC is nonsensical, given that the regulatory position was as it was. The firm was not allowed to do those things initially. And this was a business that was, its main task was meeting a whole series of DFSA requirements. And can I underline that these are not simply requirements in a rulebook. There are in this bundle a lot of communications from the DFSA saying, show us this, have a board meeting, provide us with a minute of the board meeting. There are a whole series of things. They say, get a premises, do this, do that. And what the claimant was doing was managing that. Now, he was also doing other things. There are various other canards, but that will be a matter for closing. So what we say is that the defendant manifestly was relying heavily on the claimant because he was the person who the DFSA had confidence in. He was meeting their requirements, and he was expecting to be paid. And the suggestion that someone who works on in this way is doing so out of the goodness of their heart, or in exchange for sort of unspecified minor dues that might be paid to them, or as a director, is as a non-executive director, is ridiculous, given that he was an executive director. So his function changes at the DFSA request. They want him to be a director. We say he is a director. He's clearly stated he's an executive director, and we say that he remains employed. Now, what happens again is that the claimant raises issues about his remuneration, and these are dealt with in a very dismissive fashion. Now, what is now also said is that in the course of his complaints about this, the claimant resigns, and we say that that is simply a misconstruction of the relevant email. What he makes clear is that he wants to resign, but that he's going to carry on serving pending the finding of replacement. Now, that as a matter of law is quite simply not a resignation. It's to say, oh, I'm resigning, but I'll stay around. Well, that is not a resignation. Now, the ensuing events, in terms of why are there this list of effectively unanswered questions from the claimant and unanswered requests and prevarication and delay, we now have greater clarity from the defendant's extra disclosure about what is going on, as it were, behind the scenes, and that would be the subject of cross-examination. So I just want finally to wrap up on this issue of production. We have not made a request for production following the PTR. There has been some heated correspondence about this, to which the court will doubtless be taken as necessary in closing. The point I want to underline about production is this. It became clear at the PTR, and has become ever clearer, that the defendant has produced, it has complied with what it sees as the letter of the law, and in this respect it is right. It has only produced the documents on which it seeks to rely, subject to limited further material it has provided, first pursuant to the consent order, second last week. Now, what the court needs to bear in mind about this is that from the materials that we have now had produced, it is very clear that this is a defendant that is being extremely careful about what it is saying and what it can rely on. Now, I will endeavour to submit in closing that it has gone wrong in that respect, and that things it has pleaded and said shouldn't have been. But well, it's less the pleading than the evidence, so it's going to be a matter for closing. But the point that matters is that if the court is left saying, well, goodness me, there's no evidence about this, or there's no evidence about that, it is a reasonable inference. Sorry, it is certainly not the case that the court can conclude that no such document exists. What the court is in fact able to conclude is that there is no such document which exists which supports the defendant's case. And that is a matter that will be addressed in closing. Now, in terms of the defence, I have deliberately not spent this opening dealing with the defence. We've turned on the key issues. But what we say is that a large number of the arguments evaporate once the court reaches the conclusion that the claimant remained an employee of the defendant until he terminated his employment for cause on the 11th of August 2023, which he was plainly entitled to do. And the ensuing issue, and many of these legal issues about, for example, penalty, look back, limitation, and so on, they only arise really in our submission as quantum issues. And as regards estoppel, for example, as regards other legal arguments, there has been already quite full argument in our skeleton argument. These are issues that are going to be picked up in closing. It is a case where some of the arguments raised give rise to significant issues of law. We say two things. First, we do not shrink away from addressing those, as I hope is apparent from our skeleton argument. But secondly, and very importantly, we say the correct answer here is for the court to reach its findings on the facts first, and then address the legal consequences of those. So unless I can assist you further, those are my opening submissions. And obviously, in terms of witnesses, I'll be calling the claimant to give evidence in due course. Your Honour may be muted.
I'm muted, sorry. Thank you very much for that. And I look forward to hearing about the Article 20 claims in closing, and also the defendant's argument that they are time barred. I know you've addressed this in your skeleton, but I'm interested to hear more about that particular issue, because they were introduced, as I understand, in the amended particulars of claim. So I think a time bar issue has been raised. I think you've responded to it, but it would be useful to get into the detail of that.
Can I deal with this briefly? I was mindful of time, but I think I'm afraid that there is no answer. There is no way of dealing with this except, I'm afraid, by getting out my pleading and the bundle. Yeah. So I think that there is a degree here of I wouldn't quite say cross purposes, because I think issue is clearly joined, but can I take Your Honour to page 9 of the bundle, which will be page 24 or 24, I think, of the PDF?
Which pleading is it?
This is the amended particulars of claim.
Yes.
And can I just first of all deal with the header D, breaches of the employment contract and the employment.
Yes.
I think you've muted. I don't know why.
I'm grateful. It's always been entirely clear from that these have been claims brought as both the contract and the employment law. That's the first point. The second thing is paragraph 18 failed to pay monthly wages when due, contrary to clause 1 of the standard terms and article 18 of the employment law. Yeah.
Yes.
And then what we see, and effectively the key, can I just deal first of all with article 18, and then, sorry, can I then take the court to paragraph 21 over the page?
Yes.
And then we have a breach of article 19 of the employment law. Yeah. Sorry, at paragraph 21A. And then we have articles, paragraph 22, articles 19 and 67 all pleaded. Yeah.
Yes.
So the reason that matters, Your Honour, if I may say so, is if I can just go back to the law for a moment, because I think this is where I have to say I think that we have a bit of somewhat strange position being taken. So if one looks at paragraph 18, that is the obligation. Yeah. 18.
Sorry, are we looking at the employment law?
Correct. It should be hopefully on a screen share.
Yes. Sorry, yes. 19, yes.
So 18 paydays.
Right.
That's the obligation on the employer. 19 payments following termination. Now, this is very important. An employer shall pay to an employee within 14 days after the termination date all remuneration, excluding, where applicable, any additional payments deferred in accordance with Article 18. And when then goes into the penalty provisions at 2, 3, and 4. Now, one point I'll just deal with as I'm here. Article 19.4, effectively 19.4.1, has a kind of suspensory effect on penalty while there is a dispute pending in the court. But in Article 19.1, what we say is the court does not have to go further than this. An employer shall pay to an employee within 14 days after the termination date, so that would be something like, by my rough calculations, either the 25th or the 23rd of August 23, all remuneration. Now, how is, those are the words, all remuneration. How is remuneration defined? Now, I'm going to click on the hyperlink to the definition. If I end up somewhere different, my apologies. No, I haven't. Remuneration. the aggregate of an employee's wages and additional payments. Additional payments are things like bonuses. So I'm just going to take the court to them briefly. They're here. Additional payment, any bonus, incentive, grant, commission, etc. Yeah. So this is not a case about additional payments, at least in my recollection. But when we have, sorry, I have got lost here. Wait a minute. Yes, here we go. This is where we were. Remuneration. The aggregate of an employee's wages and additional payments. What is said there is clear. And Your Honour will recall the words in Article 19, all remuneration. It doesn't say all remuneration payable after over the last 6 months. It doesn't say all remuneration just of the previous pay period. It says all remuneration. And the correct and primary way of putting this case is that the obligation that arose in the middle of August 2023 was to pay the claimant all remuneration that was due to him during the course of his employment. Now, the only argument that I see the defendant has to meet that is the argument we addressed earlier about potential discontinuity in employment. And that is the correct and primary way of putting the case. And that is, with respect, what the court should be focused on. Now, the Article 20 point, I could explain it in more detail, but it may be best if I do this in closing. But sorry, I've gone to the wrong page. I'm going to end up. The correct point here is if one goes back to English law for a moment, because this is important. These provisions, particularly here, Article 20, has a very important echo in English law. There is English law about a series of deductions, okay? And there is English law saying that a non-payment, an outright non-payment, can be also deemed a deduction. And what the added pleading to which my learned friend is taking such objection to is really a belt and bootstraps provision of relying on Article 20 and saying, well, we've alleged already the outright non-payments of Article 18 and 19, yeah? So we have already sufficiently pleaded those, we say. And therefore, if we're wrong in what is both our primary and our secondary cases, so we've got Articles 18 and 19 being together. If we're wrong on both of those, we would rely on Article 20. Now, I do have to say that there can be problems with sometimes dotting all I's and crossing all T's, because what has happened here is that what is really our third case seems to have become the focus of a huge amount of attention. I'll address it in closing, but what we say is in cases where there is a straightforward non-payment and where that has already been pleaded, it is not the case that the reference to Article 20 introduces some new and distinct cause of action, but that is effectively the disagreement between us. There is also disagreement about the rather novel question of relation back. That is a question that the DIFC court has addressed before and has found that there is no doctrine of relation back. That is an issue that is going to need to be the subject of further submissions. But I do have to say here that the reason I took Your Honour to the pleadings is that we say that these arguments that everything has to be distinctly pleaded, we say we have pleaded it. Now, what it comes down to is that the defendant says, well, because you didn't expressly refer to Article 20, then you have no claim under it. That is an argument that turns on, from recollection, judgment of, I think it's Sir Jeremy Cook, my learned friend will doubtless go to it, about the need to plead particular articles. We say that there is, if one looks at the RDC, there is no such express requirement. The implied requirement addressed by the judge in that particular case, we say that first we say it as a matter of law, it's satisfied here. And second, we say it is not right to say that you have to recite each and every article you're claiming at, particularly if, as a matter of law, what you're pleading has already been satisfied the requirements of the article. But I'm very interested by this point. It's a point I'm sure we'll have further in closing, but we say that it simply isn't a point that perhaps deserves the scrutiny it has had. So those are our submissions on it.
Thank you. That's very clear indeed. Ms. Doherty, moving on to you to the defendant's opening submissions, please.
Yes, thank you, Your Honour. Not proposing to take up an excessive amount of your time. If there are, of course, particular issues I can assist with, I'm happy to do that. Really, there are three areas I was hoping to touch on. The first is to take you to some of the core factual issues in dispute, as we say it. And in doing that, I hope to take you to at least one or two of the key documents, which no doubt you're going to see a number of times during the course of oral evidence and most likely again in closing. Second, I'm going to take you to an overview of, in effect, the defendant's principal arguments that arise from those facts in defence of this claim. And third and final, I hope to take Your Honour not at great length, because I know there's going to be more time to deal with this in closing, but to a couple of sources of law, insofar as providing you with a summary of a few of those principles might assist you ahead of hearing the factual evidence, because it's lets one have in mind what points are going to be relevant when you hear the witnesses under cross-examination. So taking those points in turn and starting with the facts, Your Honour will have gathered that there's a much wider factual context. You'll got that from pre-reading and also from what you've just heard from my learned friend. And really that's about the change in ownership of the defendant, which took place in effect from the middle of 2021 to the latter part of 2022. And there is, to some extent, plenty of factual detail and intricacy within that. Ultimately, the core of the factual dispute between the party that has arisen at some point in time is really that there's a fundamental disagreement between the claimant and the defendant about the series of discussions which took place between August and November 2022 concerning both the capacity in which the claimant would remain involved with the company and also what was being done about what he was claiming as being dues owed to him up to that point in time. And really that's what the central factual dispute focuses on. It's whether the claimant's employment was terminated in November 2022, or at least at some other point prior to when he and his solicitors wrote to the defendant asserting their own entitlement to terminate for cause on the 11th of August 2023. And whether, even putting that to one side, the claimant had devised and participated in an arrangement back in November 2022 in which his previously claimed entitlements would be paid out to him, creating, as he's termed it in his own witness evidence, a blank slate with respect to his position going forward. And if he has participated in discussions to that effect, the question raised by the defendant's defence is what the legal significance of that is. And focusing in on really that key part of the timeline, really the starting point is the 5th of July 2022. And that's when it's common ground, after it's common ground, I think there was a longer than expected period of delay. But by the time we get to the 5th of July, it's when the DFSA approve the change in control of the ownership of the defendant. There are still some steps that need to be carried out after that, but that's the point in time at which the minds start to focus on settling this question of dues and liabilities. And it seems to be, again, largely common ground that one of the sticking points, or at least the point that was in active discussion in completing any takeover, was what should happen to any of the accrued liabilities that are asserted were owed to the claimant. In respect of that issue, the claimant's own evidence is that he understood his previous dues were going to be settled by the old owner of the business, the seller, that's Mr. Singh, and he says that in his reply witness statement in paragraph 62. And so that was the basis, as one can see in the evidence, on which the parties proceeded. As the claimant himself put it, the idea behind this was that he was going to get a retrospective payment of his dues from the old owner, and that would mean that he would be starting with a blank slate when it came to the incoming owner of the business. And that's an understanding that will be explored during the course of cross-examination. What does blank slate mean in that context? And really, the defendant says that there are two things which arise from that. One, the blank slate refers to the entitlement to payment itself. And the second is that the defendant will argue further than that to say that it also refers to the nature of the claimant's relationship with the company, which was to change, and ultimately he understood to be negotiated with the incoming owner in what position he would continue to provide whatever assistance he did, and on what terms. Another issue that arises from that blank slate is also whether it is permissible for the claimant to resile from what he says was his understanding, and in the way that the defendant says that he does in bringing this claim. And with that broader context of what the issues are, the core set of documents, in some respects, in this dispute is fairly narrow. The first of those that I'd ask Your Honour to pull up, and as I said, we're going to be coming back to these, but it's page 897 from the main bundle. The PDF page number is 912. And if Your Honour has that page reference, I can see that it's in the process of being shared, which I'm grateful. It's an email chain. This is in August 2022, so it's after the approval by the DFSA, the change in ownership, which took place in July, and we can see that this chain begins on the 26th of August. It originates from the claimant, and he titles this email "End of Service Amitesh," and he writes, "May I request you to share my end of service settlement amount as at the end of August, and if you can provide the breakup," this is at the bottom of the page, "of gratuity dues, pending salary, notice pay," and he provides some explanations around that. And prior to there being any response to that, on the 30th of August, he sends a further email which says, "As discussed, I'm sharing the calculation for my end of service with the supporting documents for good order's sake." And then he makes some further explanations concerning those entitlements and attaches what he describes at the bottom of that email of the 30th of August is his end of service calculation in an Excel sheet. Now, I'll deal with this in closing, and I'll deal with it during cross-examination. Ultimately, the intent behind the claimant sending an email titled "End of Service Amitesh" and what was included in that is something for Your Honour to consider and decide upon in determining this case. The defendant's position, of course, is going to be to say that the court is entitled to take what's said out there at face value. But that was the starting point of some of these discussions. There are several iterations of the various calculations that lay behind what was to be paid to the claimant and behind what was ultimately agreed. But a relatively simple illustration of that, and also of the mechanism for payment, can be found at page 918. So it's 933 of the PDF. Which is an email chain sent again by the claimant himself. He's sending it to Mr. Singh, that's the old owner, and he's copying in a number of individuals who are representatives from Unitas. And he says, "Dear Sanjeev, apologies for the delay in responding. As requested by you, please find attached to this following email," and he refers to the company's Citibank bank statements. And then in the second bullet point below that, he says, "Calculation of the amount due to me. This calculation was checked by Amar on the 31st. I've just added the month of September and October 22 to that." So it fixes the context in which those calculations are being provided and what the calculations are said to be. And if we scroll down the page, if we could look at the table as a whole. So the bottom of page 918 and the top of page 919, one can see a table described as fund flow. And there are a number of letters in the middle column, which are ascribed to particular payments. So A, B, and C are payments being made from the defendant's bank accounts to the old owner. So that's from the Citibank account. And then another payment at C, which says it's a payment due as per the SPA. And then at the top of the next page, we have a separate category of payments at D, E, F, G, and H, which are said to relate to due to Amitesh for gratuity, for dues, for leave encashment, for 1 month's notice pay, and for work done on the withdrawal notice. Again, the nature of this email and what it was understood to have meant is going to be explored in evidence. One of the points that might assist to focus on is the structure of this payment. So what Mr. Singh is being told is that this is a checked calculation of the amount due to the claimant up to the end of October 2022. The reference in the table to the flow of funds is that there are amounts due under the SPA and in the company's bank accounts that are due to be paid out from the company to Mr. Singh, the outgoing owner. And those are sums A plus B plus C. And what we can see at the bottom of the table is that the total due to Sanjeev, the old owner, is going to be the sum of A plus B plus C minus I, where the I is the total of D, E, F, G, and H. So that's the sums payable to the claimant for gratuity dues, leave encashment, notice pay, and work on the withdrawal notice. And so what that means is that the structure of this payment is whatever amount flows to the old owner is ultimately contingent on the amounts owed to the claimant. So if the claimant is owed more, the old owner will get less, and vice versa. So that's what Unitas and the old owner are being told. There's a communication with Mr. Vellucci, the incoming UBO, which is at page 885. So that's 900 using the PDF. I don't know which page reference it most assists for me to give you. I'm happy to provide just one, but if
it's easier to search with the PDF number.
Okay, so it's page 900. So this document, it's an email from the claimant to Mr. Vellucci again with Unitas in copy. As I say, from the same date, and what we have is, in effect, what the claimant is telling Mr. Vellucci the payments relate to. He refers at the top, just above the table, 2 sentences above, he says, my dues till 5th of July will be paid by Sanjeev, and after that it will be paid by you, the approved controller. There's a table which is different in form to what we looked at in the previous email, in that it doesn't set up the breakdown of what's included in the claimant's dues, but what's provided in the sentence after the table is the explanation that the above amounts are after deducting my dues that would be paid by Sanjeev. So the way that the payment is being framed on the face of this email is that the amounts being paid to Mr. Singhal are net. So that's after deducting the claimant's dues. And again, this is perhaps more for your note, but page 974 of the bundle, which is 989. Of the PDF, that document confirms that the payments are made on the 21st of November 2022. So that's the chronology, that's what's said about the payments. What the defendant also refers to is what is going on more broadly with the claimant's status at the same time. And so if one goes to the supplementary bundle at page 86, there's a document which is an application to vary an authorized individual or withdraw. So this is a DFSA application. One can see over the page at the top, we've got a submission date, which shows that this document was submitted to the DFSA the next day. So the payment's made on the 21st, or it's given effect to on the 21st. The next day, there's an application to vary the claimant's authorized individual status. And if we go to page 90, one can see what is being changed. So it's at the top of the page to remove a licensed function. We see that the licensed function that's being removed is senior manager. And then in the middle of the page, there is the addition of a licensed function, which is the addition of the claimant as a licensed director. And we see that the date that both are proposed to commence is at the end of October, which, as we've seen, is the calculation period, in effect, for the emails that we've looked at. So the claimant had added the months of September and October. And again, it's going to be a matter to be explored during evidence and in closing. But the defendant says that this is the point in time at which the claimant's employment is terminated, and at which he knows that he's no longer an employee and that his capacity in the company changes. Precisely what that means is subject to agreement between him and the incoming UBO. But what this does is it creates, as he puts it, the blank slate. It's for the UBO and him to agree what that means. He will remain in the position formally as SEO, but in the capacity as a licensed director. And again, I'll come to the detail of this in closing, but that is a significant change, because under the DFSA's rules, there are three routes. One isn't relevant in this case, but there are materially two ways in which you can maintain the position of SEO as a matter of the DFSA's rules. One is you're a senior manager of a firm, and what that means under the DFSA's rules is that you are an employee. So it says you must be an employee and not a director. Or you can maintain that position as SEO of a firm if you are a director, without there being a requirement that you're also an employee of the firm. And so there's, in the defendant's submission, a bit of smoke and mirrors going on in the extent to which the claimant is seeking to tie his regulatory status to his employment status, because they are not one and the same thing. So he points towards the fact that the formal change from his being SEO of the company isn't affected until August, and 30th of August, I believe, 2023, meaning, well, that means that you're required to pay me as an employee up to that point in time. And we say that that's simply incorrect. There is no issue of breach here connected with the termination of the claimant's employment. One can be a director and not an employee, and there is a significance in the timing of the transition of his role, and one that he was fully aware of, we say, at the time.
Sorry, can I ask you a question?
Yes, of course.
Is there a definition in the DFSA regulations or elsewhere as to what an executive director is? Because I note on the form at page 91, it says, will the candidate be an executive or non-executive director? Please note, if applying for or holding a mandatory function, the candidate can only be an executive director. And there's a job description. I don't know if the job description has been included with this document, but
I'm not aware of the document. I don't believe that it has. When the relevant set of rules is set out in it's the general module of the handbook, and there are a couple of sources, but the main source is rule Gen 7.4, which is the section which deals with licensed functions, and is where we find set up some of the definitions. So, for example, it's Gen 7.4.2, and I'll go to the detail of this in closing, which says that a senior executive officer may be a director, partner, or senior manager of the firm. And there are various definitions which are attached to those provisions. So senior manager.
What section are you on? I've got the document open. I found it in the joint bundle of authorities. And now we have it on the screen. Thank you. So this is a senior executive officer.
Yes. So it says in B, senior executive officer can be a director, partner, or senior manager. Then at 7.4.7, one sees what's meant by senior manager, which is that it carves it. Well, it has the requirement, first of all, that one is an employee of the firm, but is also not a director.
Right, but I'm querying the distinction between executive and non-executive director. Is that defined anywhere?
For the purposes of this set of the rules, no, there's no distinction made. So the term for director is 7.4.3 deals with the license status of, well, a licensed director. And it says it's carried out by an individual who is a director of an authorized firm, rather than it being specific as to the differences between a executive or non-executive director.
Right.
As I understand it, the definition in the glossary section for director is linked back to, effectively, it's a person who appears in the register of the DIFC Registrar of Companies. So that's for a DIFC company established under the Companies Law 2004. It's a person who's a director. But I'm not aware of the material distinction in this context, but the point really that the defendant relies upon is where you have an express requirement in the general module for a senior manager to be an employee of the firm. No such requirement exists when it comes to being a director. So it's a point that doesn't really go anywhere to suggest that your licensed individual status as a SEO is somehow linked to you being an employee. It's not, and in the context of this case, it wasn't, because at the material time that we're dealing with, which is this window of time from November 2022 onwards, the claimant was acting in his capacity as a director. He was no longer a senior manager, and so the employee requirement no longer applies.
I understand what you're saying, but having looked at these regulations, it says under 7.4.2 in the DFSA rulebook, Gen 7.4.2 that you just took us to, it says that the SEO has either alone or jointly with others ultimate responsibility for the day-to-day management, supervision and control of the firm's financial services. So I suppose your point is because there's an option to be either a senior manager or a director, you would not have to be an employee to carry out those functions. If you were not an employee, just hypothetically, how would you be paid?
Well, I don't think it's necessarily invariably the case that a director in all companies would have to draw payment, or that they would take anything other than dividends from the company. It's a matter for that particular director, in whatever role they're in, to ultimately agree with the company. And really that's the point that the defendant makes, is that the arrangement known to the claimant in this case was that his position as senior manager as an employee would come to an end. He calculated his end of service entitlements on that basis. And in the period that followed, his capacity in the company would change to being a director, and that he and the incoming UBO would agree terms, in effect. Now, both the claimant and Mr. Vellucci provide evidence on that. They say that they had, well, I think there's a difference on timing, but I don't think there's a distinction between them that these discussions happened. What Mr. Vellucci says is an offer was made in January and one that wasn't accepted.
Right.
The effect of that for present purposes is that whatever agreement they might have had is effectively at large. It never came to pass that a salary was agreed. There's no claim in this case that one should imply a fresh contract of employment, or that there was some kind of fresh contract of employment that was entered into at that point in time. Again, that's neither here nor there. The position the defendant adopts is that from November, the old contract, whatever it was, is terminated. The new agreement was one which was at large and was to be reached through discussions between the claimant and Mr. Vellucci, and that never took place.
So if they never agreed, your position, I don't think, and it's not disputed that there were discussions about what payment would be made to the claimant, but is the defendant's position then if no agreement could be reached, then the claimant would carry out this function and simply not be paid anything?
As far as this claim goes, that has to be the analysis. There are worlds in which individuals in this position would go on to claim that one could find an implied contract of employment from the facts of the case. So where you have a scenario in which someone is performing some work, they can go to the court and say, well, I was working as an employee. We never formalized a contract, but I want the court to find that there was such a contract of employment. Now, when faced with that sort of a task, the court will look at the case law in this area, some of which I'll touch upon briefly later, because I think it is at least helpful in framing one's view. You look at what the irreducible minimums are when it comes to finding that there's a contract of employment, as opposed to finding an implied contract of some other kind, a contract for service or something like that. Now, that requires a factual investigation of the circumstances. It requires the court to determine, if it does find that there's a contract, what the terms are, and so on. The main point is that that's not the pleaded case that's before the court. So it's not to say that there's not some legal analysis in which the claimant could have asserted that there's some source of entitlement here, but he hasn't done that. Instead, we say he has wrongly asserted some continuation of his prior course of employment, which we say is at odds with the facts leading up to these payments being made in November and to the changes that took place in November 2022.
Right. And just 2 points. I didn't follow your point about dividends. I mean, I would assume they will be paid to shareholders, not directors, but we don't have to deal with that now. You can deal with that in closings if you need to.
Yes.
Yeah.
I say that, for example, in the context of a small company, it's not unusual for someone to be a director shareholder with 100% control of the company. They will not invariably draw a salary from the company. They might, but they also might not. And that there are other ways in which, the point I was making is there are other ways in which directors can and are remunerated other than by being employees. So the point really is that there's no requirement that a director is an employee.
Certainly, but I mean, I don't think it's disputed that the claimant doesn't have any ownership interest in this business. So perhaps those types of ways of being paid may not be applicable. But the second point, again, just to confirm, you're saying that it's not open to the court to find that there was some implied contract post November 2022, because that's not the way that the claimant has put his case. He has put it on a continuous employment basis rather than a new implied employment contract basis. Is that correct?
Yes, correct. So it's not open to the claimant at this point in time to advance a case like that. But I sense that Your Honour wanted to know what the analysis might be for someone who finds themselves in that scenario, and that's to give you an example of what the analysis might look like in those circumstances. But even then, and I underscore the point, there are differences in the way that one would ordinarily go about framing an employment contract as compared with some other form of service contract. And that requires factual investigations of the extent of someone's control over an employee and so on. Those are issues which would have been considered in that sort of claim had it been brought. But I simply make the distinction that even if one were to find that there was some form of contractual relationship, it is by no means inevitable that one would find an employment relationship within that.
I understand. Thank you.
So as I say, but by the time we get to that section of the chronology, we say that the key point for the purposes of determining this case is that there's no subsisting employment contract. And we say that when one looks at the surrounding circumstances, not only at the point in time which payments were calculated and made, but also thereafter, it's unrealistic to suggest that there was continued employment. But in any event, if one jumps slightly forward in the chronology to page 1131 of the bundle, the main bundle,
Yes.
This is the email from the 18th of March, where the claimant says, with reference to our discussion today on the subject of my resignation from the board and the role of SEO, I would like to tender my resignation. He requests dues. Mr. Vellucci says, "What dues?" The claimant says, "My salary and benefits per my employment contract." And Mr. Vellucci says, "I'm confused. What are you talking about? I gave you an offer which you turned down." And again, I won't labour the point now. It's really for closing, but it's ultimately for Your Honour to determine whether, as a matter of fact, Mr. Vellucci's reaction to that is consistent with some of the points I've raised or not. But in any event, the point we make is the point the defendant makes is to say that to the extent that there could have been any doubt about the claimant's employment status, by the time we get this exchange, really, there couldn't be. And the claimant, I think, takes points on this which are slightly misguided insofar as they miss what point the defendant seeks to make by these emails. I think the claimant's thrust of the claimant's submission is, well, it's extraordinary that if you thought he resigned in March 2023, that you haven't sought to make that the focal point of your case. That's slightly missing the core point. When the claimant sends this email, the defendant's position is that Mr. Vellucci thinks already that he's no longer an employee. And so his response is obviously tempered by that. He says, "What are you talking about?" And one of the matters that Your Honour will have to consider, we say, and determine in due course, is whether, having provided this communication which says, "I resign, I would like to tender my resignation," and in the face of the defendant's rejection of an assertion that the claimant was even employed in the first place, is it really within the claimant's gift in those circumstances to proceed on the basis that he can assert an ongoing and indefinite right to say that he's an employee until his time of choosing? Because if one hands in resignation to a business and the business says you're not an employee, there's somewhat of an implied answer to that to say, well, if you're not an employee, we don't want you to continue on any longer. We accept your resignation. And whether, if Your Honour was to take issue with there being any resignation in November, this in any event draws a line under that.
But isn't there an issue because he was the SEO, which is a mandatory role, and he wouldn't be able to leave immediately until a replacement was found because the firm wouldn't be able to function without that role being filled. Isn't that the case?
Well, there are two answers to that, one of which will be borne out during the evidence, which is one can see from the facts the steps were taken to replace the claimant before he subsequently tenders his resignation, or sorry, his termination on the 11th of August. So as a matter of fact, we say that that bit of the claimant's analysis doesn't work. But this comes back as a matter of principle to the points which we've already discussed, which is there is no inherent link between one being an employee and one being the SEO of a company, because one does not have to, under the DFSA's rules, be an employee to hold that status. So that's why this distinction between one being an SEO and a senior manager, as compared with being an SEO and a director, is critical to that analysis. And I think, for what it's worth, the claimant himself doesn't even go that far, because his ultimate replacement, or the DFSA finally signing off on his replacement as SEO, doesn't take place until the 31st of August, 2023, and yet he says that his contract terminated on the 11th. So he accepts that there is no direct link between his status as SEO as a matter of formality and his status as an employee as a matter of law. So they're not the same thing. It is entirely possible for one, for regulatory purposes, to remain as the SEO in their capacity as director, but also to cease any employment that they have. One can't see that link being there. And in any event, for present purposes, what is or is not of concern to the regulator does not have a bearing on the question which is presented in this case, which is, was the claimant an employee at the points in time in which he asserts?
Okay.
So it falls from that when one looks at the facts, Your Honour is going to be asked to weigh up the reality of what the claimant claims, as well as the legal consequences flowing from his conduct, particularly in the lead up to November 2022, and to weigh those against his claimed entitlements. And I'll deal with the summary of the points that the defendant takes, which arise from those facts, and break it down in essence in a summary of the position that you'll hear more about in closing. So the first point is in relation to what I'll call the claimant's prospective entitlements. So that would be entitlement to any payments post-dating November 2022. As a matter of fact and law, we say those entitlements never accrue because his employment was terminated in November 2022. Negotiations concerning entry into a fresh contract took place, but its common ground were never concluded, and so no such contract exists, or at the very least, no other form of contract is pleaded to have been entered into. Second, in relation to the claimant's past dues, so that is the pre-November 2022 entitlements, the defendant says that the nature of the claimant's actions in the lead up to those payments being made, and which led to payments being made by the company to both him and to Mr. Singh are such that he's stopped from asserting those entitlements. He made clear statements which he knew were of importance concerning how his past claims would be apportioned, and payments were made out by the defendant on that basis, only for him to come back some months later and claim, having never told anyone at the time it was his intention to do so, and despite what he said about there being a blank slate, that he's owed in excess of $250,000 in back pay. Once one then gets over those points, we say that there are further layers upon layers on which both as a whole and also individual elements of the claimant's claim fails. And one of those points, which is of considerable significance, is limitation, because the claimant's claim was not brought until the 9th of February 2024. The amended aspects of his claim were not introduced until the 28th of May 2024. And I take it to be accepted now that there is no principle of relation back in the DIFC, but to the extent there's any doubt about that, it has been dealt with in a very clear judgment from Justice Sir Jeremy Cook, which we'll come to again in closing. Under the DIFC employment law, you have a strict 6-month window in which to bring your claim. So if it's a claim upon termination, it's 6 months of termination. There is a host of DIFC case law, again, which we'll get to in closing, but it's the case of Lutfi and other cases that followed it at first instance, which tell us about how one needs to read the employment law alongside other sources of potential obligations, contractual or tortious, within the DIFC. And the clear thrust of all of those cases is that where you have a self-contained code which is intended to deal with employment disputes, if you are an employee, your entitlements arise under the employment law. You do not have a freestanding right to assert that you have some separate contractual claim. And indeed, it would make no sense for that to be the case, because otherwise, what would the point be of the limitation provisions in the employment law if one could simply skirt around them by saying, well, it's a contract, so it's 6 years? If that was the case, there would be absolutely no reason why the employment law would impose stricter limits. Now, when one takes that as given, which we say it ought to be, the claimant really has no margin for error. If Your Honour disagrees with him that his employment terminated on the 11th of August, his claim will fail, and there is no way around that. And for reasons that I've already alluded to, in which we'll explore in more depth when we look at some of the factual circumstances in evidence, we say that the claimant's employment terminated long before that. And I should say that on limitation, there are a number of sub-issues that arise. I think some of it might have been lost in the noise. For example, when it comes to what the effect of the end of a fixed-term contract is as a matter of law. So just to be clear, when we make points about that, those are about limitation provisions kicking in with respect to specific entitlements. It's accepted that there was a period of employment which continued after the end of a fixed term contract, but we say as a matter of law, you've still got to bring your claim within 6 months of that period if there's anything undue, or if there's anything that is due and not paid at the end of that period. And then the fourth point, which again is an overarching one, relates to limitations which are fixed by statute when it comes to employment claims, which are expressly introduced to limit the claims period and to prevent precisely this sort of case coming before the court, claiming dues which go back a long, long way in time. And that's a point of legal principle that I was going to take Your Honour to, which is going to the employment law itself at the authorities bundle, page 1064. So the first is Article 10, which is the general limitation period, which applies and says claims should be brought within 6 months after the relevant employee's termination date, subject to Article 22 and 61(2). So the default period is a strict 6-month time limit within from termination. Otherwise, the court shall not consider the claim. Article 61(2) isn't relevant in this context, but Article 20 sub paragraph 2 at page 1070 is, and this is a set of provisions which were introduced subsequently to the employment law. And the point of these provisions is that they make clear that if you're saying that someone has not paid me an amount I'm due under an employment contract, you don't bring that claim after you've been terminated some years later. You bring that claim from within employment, which obviously makes sense. If in the normal course someone hasn't paid your salary for the last 4 months, what you should do is, as an employee, pursue your employer, and this is what gives you the ability to do that. So it says, in relation to claims brought by an employee, that an employer has made an unlawful deduction from their remuneration or otherwise failed to pay that employee remuneration to which that employee is entitled under their employment contract or this law, or received a payment from that employee in breach of Article 21, and this changes the limitation provisions for those claims which should be brought within employment. And it says that a court should not consider the claim unless it's presented before the end of the period of 6 months, beginning with, in the case of a claim relating to a deduction, the date of payment of the remuneration from which the deduction was made, or on the date the remuneration should have been paid, or where you've got a series of deductions, it's effectively from the non-payment of the remuneration or payments received, or a combination of the same, the date of the last in the series of deductions. Now, one of the important and express purposes of the introduction in this provision is precisely to limit the claims period. And this has been dealt with both, I'll deal with it in closing, but it's been dealt with both by a judgment of Justice Lemierre in a case called Morcath and Expresso, and he refers to it, but it was also set out in express terms in the consultation paper, which led to the introduction of these provisions. And what it says is that you have, in effect, a 6-month cap on claims. And the point is that you're not, as an employee, entitled to sit back and wait for several years, only subsequently or even after termination to claim that you haven't been paid significant sums. It's supposed to draw a line under it. And where one has this 6-month backstop, what we say is that on the claimant's best plausible case, his entitlements in this case can only go back to February 2023 and not to March 2021, as he claims. I'll deal.
Sorry, I had a question. Sorry,
Yes.
Do we have that consultation paper in the authorities?
I had initially struggled to find it. I did manage to find it last night. Just dive through the DIFC's website to get it. So, assuming there's no disagreement, I'm happy to have it added. The relevant sections of it are also, for what it's worth, quoted by Justice Lemierre in the Morcath judgment, which I've also set out.
That's fine. I'll read the relevant provisions in that judgment, and then I'll look it up if needed.
They're also in my skeleton argument, referred to. So it's paragraph 79 of my skeleton, and it's within the chunk of text that's quoted.
Yeah.
But it's paragraph 184.
Yes.
Justice Lemierre's judgment. So that refers to the consultation paper.
Right. And just one more question on this. I understand the claimant to be saying that even if there were successive fixed term contracts of employment for 2-year periods entered into in June 20 and June 22, there was continuous employment as defined in the, well, it's actually not defined, but as referred to in the DIFC employment law. You don't have to address that now, but perhaps you could address that in closing.
Yes, well, I'm happy to address you briefly now. We obviously don't agree with that point. So the provisions which deal with continuous employment in the DIFC employment law are specific to calculation of dues provisions. They don't provide basis for calculating entitlements, or indeed, nor do they say what happens at the end of a fixed term contract when it comes to other aspects of entitlements. And I'll deal with some of the specific ways that you can see that play out, for example, in a fixed term contract when it comes to things like leave entitlements. So there is law on this. This is in Abdul Salam and Expresso. But if one thinks about, for example, a 1-year fixed term contract, you get a period of time in which you're supposed to accrue and take annual leave. Now, if your fixed term contract is terminated prior to its natural conclusion 1 year later, and you've got some periods of leave that you haven't taken, the general provision under the employment law is that you can claim for accrued but unused annual leave. If, however, you get to the end of your fixed term and the contract terminates automatically on its fixed term, you can't go back and say, well, I didn't take any leave, so I'm entitled to an uplift on what my salary under the contract should be. Which of course makes sense. Leave in that context is not meant to be a boost to remuneration. It's meant to be a encouragement to a worker to take leave. And in that context, it's a use it or lose it benefit. So if at the end of your 2-year fixed term contract, you say you've got leave that accrued but you hadn't taken, the effect of the provisions of the employment law dealing with termination, so that's the definition section, at that point in time, your entitlements, your contract comes to an end, your accrued entitlements terminate. If you had any claim at that point in time, you have to bring it at that point in time.
Right.
That's our construction of the provisions of the employment law, and we say that that's unaffected by the provisions which deal with dues.
Right, understood.
The final 2 points I'll deal with very briefly, because I think it will assist in your consideration of the evidence is simply a summary of the law on estoppel, which will no doubt be familiar to Your Honour. There's a very succinct statement, which I can give you the reference to in Steria and Hutchinson, which is in the alternative bundle at page 462.
Do you mean the authorities bundle?
Sorry, the authority bundle.
462.
Yes.
Yes.
And it's in paragraph 93, which is the three classic requirements: clear representation or promise, upon which it is reasonably foreseeable that the other party, an act on the part of one party which is reasonably taken in reliance of that representation and promise, and after the act has been taken, being able to show that they will suffer detriment if not held to that representation or promise. So when one is considering the evidence and looking at these events in the lead up, in particular to November 2022, it's what representations was the claimant making concerning the payments that were made by the defendant at that time, whether the decision to act upon those representations and to make the payment in reliance upon promises, for example, of there being a blank slate, was reasonable, and whether, in the context, the defendant would suffer detriment if the claimant were permitted to resile from those representations, and, for example, to continue to claim sums that were thought to have already been paid, or to continue in employment. And so that's just to fix the framework on which you hear the evidence. And the other point I wish to refer Your Honour to, and this is the last point I make, is to provide some legal context for what one would normally expect within an employment relationship. So the case I've referred to in my skeleton argument on this point is Cable and Wireless and Muscat. And I should be clear that these are statements which are made in a context which I discussed with Your Honour earlier. So that's where one is investigating where there are circumstances giving rise to an implied contract of employment, which is not this case, but in any event might provide some assistance when Your Honour is considering the reality of the situation as it existed after November 2022, in a period where the claimant claims that he was an employee and where the defendant says that his employment had been terminated. And so this is the authorities bundle, page 841, and paragraph 32, which appears at the bottom of the page, which is, this is in the context of statutory employment rights under the Employment Rights Act. Now, there's no real material distinction in the definition of an employee under the Employment Rights Act. The employment law and the DIFC, in effect, lifts the same definition. So we're not talking on this particular point at cross purposes. But what's been said here is that there is an irreducible minimum of mutuality of obligation necessary to support a contract of employment, and it's the obligation of an employer to provide work and the obligation on the worker to perform it. And that mutuality of obligation must be accompanied by a sufficient degree of control by the employer over the worker. And that refers back to some well-established English case law. And paragraph 35 at the bottom of the next page, it's summarized in the first sentence that the view of the majority in the Dacas case is correct. The essentials of a contract of employment are the obligation to provide work for remuneration and the obligation to perform it coupled with control. So that is something that Your Honour just may wish to have in mind when one looks at how the claimant acted during this relevant period after November 2022, how he managed the work he says that he carried out, where he did that work, how he managed his time, how he responded to requests made of him. And this might give Your Honour some indication of whether or not he credibly saw himself as an employee at this time. That's all I'd hope to say by way of opening. I'm happy to answer any questions. I'm sure that we'll get into a lot of this in greater detail during closing.
That's very helpful indeed. Thank you. Just one thing I will say in advance of closings on Wednesday is that I found the agreed list of issues a helpful roadmap. I wouldn't necessarily decide the issues in the order set out in the agreed list of issues, because depending on how some issues are decided, other issues will fall away. But it occurred to me that it may be possible to narrow some of the issues. For example, I wasn't sure if there was still a pending issue relating to the claimant's visa. I had understood that it had now been cancelled, so I wonder if that issue falls away. I know the defendant, for example, had put the claimant to proof of the novation of the contract. I understand why that was done in the defence. The impression given is that the defendant maybe didn't have all the documents predating the change in ownership of the defendant. But I just wonder, now that we are at the stage that we are at, everyone's seen all the documents on the record, I wonder if we can narrow some of the issues and whether the defendant still wants to put the claimant to proof of various issues that it perhaps may not be necessary for us to spend time on. I'll leave it there, but perhaps you could both consider whether all the issues are still live, and maybe we could have a quick discussion at the beginning of Wednesday before we hear closing submissions. Would that work for both of you? I'll start with Claimant's Counsel.
In terms of whether there are matters that we can state or agreed, was this by the end of, Tuesday? Was that your Honour's suggestion?
No, just when we open closings, I just need to know if all the issues in the list of issues are still live, or if we can narrow some of them.
I think that would be helpful. The only mundane point I make is I will be trying to do that. I will be trying to do that. I think that the concern here is always that closings do take a lot of work, so an ancillary line of correspondence could be difficult. But I think as long as it's brief, and everyone knows what they're doing and we're not arguing, then hopefully I think it could be very helpful to the court, and so we'll endeavour to do that.
I mean, if you can liaise, or you could even just address me on Wednesday that the issues that each of you think are no longer live, whether the defendant is willing not to put the claimant to proof of the various issues that I think it was putting the claimant to proof on. I mean, you can address me separately. If you have time to liaise, wonderful. I do appreciate there's a lot of work to be done for closings. I'll hear from you now, Mr. Doherty.
There's just one point arising from the closing. Obviously, there's a lot we disagree on, but there's just one specific point. I had not understood it to be a pleaded issue that the claimant failed to satisfy the sort of irreducible minimum of obligation test, couldn't have been as a matter of law an employee and so on. The reason I mentioned that is I think if one was into arguments of some form of independent contractorship, that would require evidence, particularly in the DIFC, as to visa. So I understand. I'm happy with Mr. Doherty referring to the tests and saying that they can inform the court, but I think that it isn't a pleaded defence that the claimant was not capable as a matter of law of being an employee by virtue, for example, of an absence of control on him. I mean, that simply isn't a pleaded defence, and it would have needed to be addressed in evidence. So I just want to mention that point.
Thank you. Mr. Doherty.
I don't think we're at cross purposes on that. I think we put it as this is some law in a slightly distinct area, which might inform the court's reading of some of the evidence on the pleaded issues. But it's not. It's just not a case that's put that there was somehow a contract of employment that arose from nothing. It's really just it's to provide an illustration for the court's assistance of what, as a matter of law, an employment relationship is expected to look like. I don't think we put it any higher than that.
That's understood.
Thank you. And Vistati, you can think about whether we can narrow any of the issues from the defendant's point of view. If you both have a chance to liaise, to agree, that's wonderful. But if you don't, I'm happy we can have a discussion before we hear closings. Right, I suggest we take a very short break. We can check whether the claimant's disclosure statement is issued, and I suggest we reconvene at 11:35 a.m. UK time, which is 2:35 p.m. UAE time. All right. Thank you.
Thank you.
So, just to clarify that the Mr. Gahlowt is at Stevenson Harwood.
Right, well, we'll hand over to the registry to administer the oath or affirmation.
Good afternoon. Sorry, I believe your microphone is switched off or on mute.
Hi.
Perfect, thank you. Can you please confirm if you are swearing in by affirming or on oath?
On oath?
Do you have a copy of the Holy Book in front of you?
No, I don't. I can affirm.
Okay. Can you please confirm your name and occupation for the court's record?
My name is Amitesh Gahlowt. I am the claimant in this case, and I am an experienced financial professional for more than 22 years.
Please repeat after me. I affirm that I will say nothing
I affirm that I will say nothing
but the truth.
but the truth.
Thank you, Your Honor.
Thank you.
Now, Mr. Gahlowt, I understand that you're in a room on your own. If you're having problems with documents, can you please let us know? And once you let us know, I'll ask the judge for someone to come and help you with documents. Is that okay?
Sure, thank you.
Do you have access to the trial bundle?
Yes, I do have.
Can I take you, please, within that bundle? Now, there's a discrepancy between the PDF, but if I could ask you to find page 128, which is 15 more, so it would be 143 of the PDF.
128 you said, right?
Yes, is the number in the bottom right, but
Yes.
in the PDF, have you got a hard copy or an electronic copy?
I have a hard copy.
Okay, so if you go to page 128, do you see the document there?
Yes.
Is that your witness statement?
Yes, this is my witness statement.
Are there any corrections you wish to make to this document?
Second witness statement, no.
So can I then take you to page 163, please? Is that your signature?
Yes.
Is that your truthful evidence to the court?
Yes.
Can I then take you, please, to page 165?
Yes.
This is your evidence in reply, correct?
Correct.
Are there any corrections you want to make to this document?
Yes, there are corrections to this document in terms of certain names and certain points.
Okay, could you explain what those are?
Would it be possible to screen share the witness statement so we can all follow? I think it might be easier. If it's possible. If not, then I'll follow it separately.
Are those in, I'm just mindful that I've got the hard copy and I'm going through. Would those instructing me be able to share would Stevenson Hall would be able to share the electronic bundle? If not, I'll have a go myself. I think it may just be easier because I noticed when Mr. Doherty was doing that, it was rather smoother than my own.
That's fine. Let's just stick to the hard copy bundles for the moment. Let's go to, are we going to specific paragraph numbers?
Yes, Mr. Gahlowt, if you could go to the specific paragraph numbers.
Can I take my time? Because I can summarize what correction I wanted to make, but if you want me to go, I will have to just read and figure out which one is where.
Well, why don't you explain the correction and I'll try and find the paragraph number.
So there are some points where the name has been written as Mr. Magami, which is not Mr. Magami, but it will be Mr. Sagir Mohammed.
Is this page? Sorry, I've just very straightforwardly done a word search. So can I take you to page 169? The end of paragraph 13.
May I make a suggestion? If it is only names that have to be corrected, it seems that perhaps not much will turn on this. Perhaps it might be possible to find the relevant paragraph numbers and we could deal with this in re-examination just to make sure that we have the correct evidence and the correct names. But if it's going to take a bit of time now and those paragraph numbers are not to hand, we could perhaps move shortly to cross-examination. Would that work? If it is only a question of some names.
So, Your Honor, this question is to me.
I'm actually asking, I'm asking your counsel. Just thinking of an efficient way to proceed.
Mr. Gahlowt, let me put it this way: are there corrections that are beyond names? Are there any other corrections you wish to make?
There's one correction which is to the cancellation of visa. I think I would like to make a correction there.
And what is the correction?
So, okay. The correction is that my visa was not cancelled for almost 2 years. And I had to approach eventually to the court to get my visa cancelled.
Yes. Yes. Okay. Just arising out of that, actually, I do have a supplemental question, which I would like to ask you on that with the court's leave. Do you have the supplemental bundle there before you as well?
Yes.
Can I take you, please, to page 202? What is that document?
So this document is a DIFC employee permit cancellation with pending dues, a format dated 23rd of October 2024.
And what is its significance?
So the significance is that during this time, I had to travel to India and I was requesting for my visa to be cancelled. And I think my lawyers were in touch with the defendant's lawyers, and it was shared by them. But by that time, I was already in India, and I had to cut short my visit and come back before my visa expired. And then I had reached out to court to get that order to get my visa cancelled. And I had traveled to India for a bereavement.
I now want to go also within the supplemental bundle, please, to some documents that have its common ground, have been produced by the defendant since the last hearing. Can I ask you, please, to go to page 182.
Yeah.
Two questions. First, was this an email you saw at the time?
No.
Second, can you help the court as to who Edwin is or may be?
Edwin over here, in my view, is he was the SEO of the landlord, from where we rather co-investing sublet the lease between October 2022, which was finalized sometimes in December. So Edwin was the SEO of that particular firm. The firm name was Neo Vision Ventures, which happened to be the landlord for Co-Investing's premises that was leased.
Can I now take you to page 197? Was this an email you saw at the time?
I'm sorry, Your Honour, to jump in, but are we going to be doing this for every document that's
No.
it's not copied into? I hadn't anticipated we'd be giving over this quite so much time to examination in chief, frankly. Or did I intend to approach chief of the defendant's witnesses in this way?
I understand. We do have limited time, Dr. Bickford-Smith. Do you have many more questions? I suppose that it might be possible for some of these documents to be referred to in submissions rather than examination in chief?
I was attentive, Your Honour, to two issues. The first being the need to lead the evidence, because this is material that would have been covered in the claimant's evidence.
I understand if you had the documents. Can you give
correct.
us a time? I'm just very conscious of time, and I know
This is
that
the
yes.
I've got two more to refer to. So in fact,
Okay.
I tell you what I will do then. Instead of that, because I think that the key point here is in many ways the question I was going to ask at the end of these. So if I can go back to the trial bundle.
Yes. What page number?
1190 hard copy.
1205.
1205. Can I take you, Mr. Gahlowt, to this document? Now, was this a document you saw at the time? The attachment to this document, again, I'm saving time, but the attachment to this document we see at page 1199. Was this a document you saw at the time? And can
Yes,
I
did.
Can I take you particularly to 1200 PDF 1215, which unfortunately one has to flip on its side. General compliance update, and you see an update there. Is that update, and specifically the third point, was that your understanding at the time?
Sorry, Johan, but I think this is in the claimant's reply witness statement.
Okay, well, I think that without further ado, therefore, I will just. I think it's a fair question for the witness, given the new documents. I mean, Your Honour, just to say this, the point, and this to some extent indeed arises out of the opening submission. It's been said, how can the claimant maintain his status as an employee in the face of these emails? And it seems to me legitimate to take the claimant to this document.
Let's ask one question, and then I think we're going to have to move on to cross-examination.
Well, the question is this: Did you, at the time this document was sent, consider yourself to be an employee of the claimant or not? I
did. Yes.
Those are my questions. I had one final supplementary question, which is unrelated to any of this, which arises simply out of the supplemental bundle at page 1. There is an HR manual in there. And at page 3, we see a comment from IA1, and the question was whether the claimant can assist the court with who IA1 was. So that was a question for you, Mr. Gahlowt.
Sorry, can you repeat your question, please?
Page 3 of the bundle, of the supplemental bundle.
Yes.
Who is IA1?
IA1 is Ishaq Aslam, who's the compliance officer assisting at that time from Unitas.
Those are my questions. If you wait there will be more questions.
Thank you. Can I just confirm, you have confirmed that the claimant's evidence, you confirmed all 3 witness statements, because I know we got distracted because there were corrections to be made.
Yes. The final witness statement is I think the one that was being sent to the court today about production, but I haven't got a copy of that.
Okay.
It may be that I'm afraid my email may be.
That's fine. Are we content? I don't know if Ms. Doherty wants to refer to that statement, but presumably, are you content that if he has a copy of it, he can refer to it if he wants to?
Yes.
Yes, fine. And what are we going to do about the corrections? I'm happy. I'm just quite conscious of time. I don't mind in re-examination if we go through those painstakingly, because I suspect that nothing is going to turn on them. We probably need them for the record. But I just want to, before time moves on much further, I want to get on to cross-examination. So let's deal with that in re-examination. And if you don't know the relevant paragraph numbers, you can take the witness to them. Just one question before we move to cross-examination. May I ask you, witness, how may we best pronounce your name? How may we best address you?
Amitesh.
I mean, I think we're going to call you by your last name. What is the pronunciation, please?
It's Gahlowt. Gahlowt.
Gahlowt. Gahlowt.
Yes. Yes.
Okay, thank you. So, Mr. Gahlowt, you're now going to be asked some questions in cross-examination by the defendant's counsel, Mr. Doherty.
Yes.
Thank you. Afternoon, Mr. Gahlowt. I want to start with paragraph 23 of your second witness statement. That's at page 134. It's 149 of the PDF.
If we're going to screen share everything, then it may not be necessary for Mr. Gahlowt to look through the hard copy bundles. We might be able to go through quicker. So if we're going to screen share everything, let's do that. Let's try and make sure that it's big enough to be legible. And Mr. Gahlowt, by all means, if you want to refer to the hard copies, you can, but we're probably going to get through this more efficiently if you look at the screen. And I think Mr. Doherty will show you the documents that he's going to be referring to.
Sure, thank you.
Thank you. You'll see it's the final sentence of paragraph 23. You refer to the DFSA's rules. You say to be appointed as SEO, you need to be a director, partner, or senior manager of a regulated entity. And you then say to be appointed as a senior manager, you need to be an employee of that regulated entity. And you said you were an employee both at the time of your appointment and throughout the relevant period. I've got some questions for you about that. Perhaps first of all, if we can put it into context and we could look at page 453 of the bundle, please. That's 468 of the PDF. And here we can see there's an email from the 3rd of February 2020. Your name's in the subject. It says, "Dear Mr. Gahlowt, the DFSA received your firm's application for granting authorized individual status." And it refers there to your licensed functions at that time of senior executive officer and senior manager. So when you were initially authorized by the DFSA as senior executive officer, your further capacity was as a senior manager, correct?
So I was continuing with my employment. I was aware that I'm being made senior executive officer. Now I understand that to be a senior executive officer, you have to be a senior manager or director, partner, or something like that. So at that point in time, I was not aware that I'm additionally being appointed as senior manager. I assume that it is quite evident that I am the SEO and I'm taking a senior management role.
Well, pausing there, the email you get from the DFSA, it says, in respect of the following licensed functions, and it tells you that it's senior executive officer and senior manager, correct?
Correct.
And your authorization in that capacity was from the 3rd of February 2020, correct?
Correct.
And if we could open up, please, the authorities bundle, page 117.
Sorry, which bundle?
This is going to be...
It'll be screen shared with you, Mr. Gahlowt.
Yeah.
For the moment, you don't have to open anything.
So bear with me, Your Honour. I think it's 1117, not 117. So 1117. So in your witness statement, what you're saying is to be a senior manager, you need to be an employee of the regulated entity. And if you look at the bottom of this page, this appears to be where you're deriving that from. So if you see 7.4.2 at the bottom, do you have that?
Yes.
So the senior executive officer function is carried out by an individual who, and then there's A, which refers to day-to-day management of the firm, and then B says is a director, partner, or senior manager of the firm. So first question is, do you agree that as an SEO, you can be either a director, partner, or senior manager?
Yes, I agree to this point, which you have shown me on this document in the rule book.
Yeah.
Can you repeat me a previous question?
And if we look at 1118, so the same authorities bundle, page 1118, at 7.4.7, is the title senior manager. And that says that the senior manager function is carried out by an individual who is responsible either alone or jointly for the management, supervision, or control of parts of an authorized firm's financial services. And that says is an employee of the authorized firm and is not a director of the authorized firm. So is that why you say that to be a senior manager, you have to be an employee of the firm?
No, I was an employee and I was promoted as SEO. So I think to be an SEO, you had to be a senior manager, and thereby my senior manager came into existence on the form or the approval that we received from DFSA.
Just to be
I'm
clear,
not
and
saying that.
I'll read back to you what you say in your statement. You say I'm aware under the DFSA's rules to be appointed as SEO, you need to be a director, partner, or senior manager. And you say to be appointed as a senior manager, you need to be an employee. So my question to you is whether that's what your witness statement is referring to.
Can you show me the witness statement that you're referring to? What you're asking now? I understand your question.
Yeah, page 134, the main bundle.
Is someone going to put that on the screen?
So that's page it's 149 in the internal numbering of the PDF of the main bundle. The bottom of paragraph 23, you say, I am aware that under the DFSA's rules, and you make reference to you need to be an employee of the regulated entity in order to be appointed a senior manager. And my question to you is relatively straightforward, whether what you're referring to there is the DFSA rules that we've just looked at.
No, I'm not referring to the rule, but yes, I am aware, and specifically when I was making this statement, I was aware that a SEO has to be a director, partner, or a senior manager. When that application was made, I was not aware that this is one of the prerequisite requirement. It was done by the compliance officer and it was accepted by all.
Right. So this is something that you have gained an awareness of through this case. Is that what you're saying?
Through this case, through ongoing dealing after being appointed as an SEO, and yeah.
And go back to the authorities bundle at 1118, please.
On
And if you look under licensed director 7.4.3, the requirement of being an employee that you referred to in your witness statement in connection with being a senior manager, there is no reference to that, is there, when you're a licensed director?
Yeah, so I read this point and then what's your question? Can you repeat it?
There is no requirement where if you're a licensed director that you're also an employee, correct?
Yeah, maybe there is not a requirement, but that doesn't mean that I was not an employee.
Can we go to page 897 of the PDF? This is an email which should hopefully come up on screen in a second. So it's page 882 of the bundle, 897 of the PDF, sent by the DFSA. From Saida Al-Balishi. Sorry, this should be, it's 897 of the PDF, 882 of the bundle. This is in the 5th of July, titled Approval, Change in Control. Dear Amitesh, hope you find this email well. The DFSA has approved your change in control application. Please note this approval for change of control is valid for a period of time under General 11.8.6. Kindly find attached the change in control letter. The letter sets out the next steps which should be taken by the firm. So you're aware the DFSA approved the change in control on the 5th of July, yes?
Yes.
Presumably by that time, you would accept that that was longer than it had been expected the change in control would have taken.
There is no specified time period from the time application has been made for change of control. So I cannot comment like that it is taken long. There has been many reasons for the delay, but if I have to say that it has taken long, yes, it is long, if I may say.
There was delay, I think you said. There were delays.
Yeah, there were delays, yes.
Yeah. And I think, for example, one of those delays was that in the middle of the process, the DFSA issued a preliminary decision notice to withdraw the company's licenses.
Yes, that's one of the delays, yes.
And that was something that you had to deal with, was it?
Yes.
So some of the work you did during this period was addressing the DFSA's withdrawal notice.
Yeah, preparing for the oral representations and the written representation, putting everything across, answering all the questions and concern on that withdrawal notice.
And the final sentence of the email we just looked at, it said the letter sets out the next steps that should be taken by the firm. So once you've got the approval from the DFSA on the 5th of July, it's right, isn't there, that there were still a number of steps that needed to be completed first in order to fully give effect to the change in control?
Yeah, yes.
If we go, please, to 881 from the same email chain. We can see this is a response sent by Isaac Aslam, saying, thank you, Saida. I echo the comments made by Amitesh. And it's the second paragraph. He's asking, would you like for evidence to be produced as we complete them or in one go? And he says it will take approximately 2 months to complete. So at this point in time, in July, on the 5th of July, 2022, it's anticipated roughly that the final steps in the change in control process are going to take a couple of months to complete. Yes? Was that your understanding?
I'm going to say thank you for asking this question, but can I go? There is a reference to another email to that, wherein he says that I echoes Amitesh concern. So can I get the full perspective before I give my answer to this? I'm going to say if it's possible.
Well, We can look at it if we need to. It's a relatively straightforward question about whether your understanding at the time was that the final steps were going to take a couple of months to complete.
I will not say that I was certain that it will take a couple of months. I was certain that there were conditions mentioned on the change of control approval, authorization or approval from DFSA, and those conditions had to be met. How much time will it take? I had no idea about it. It could happen very soon, or it could have taken a longer time, how quickly we acted on it.
Sure. Well, I mean, Mr. Aslam, I think, was acting as the compliance officer. You would have known, because you were copied in, that he thought it was going to take a couple of months.
Again, I say that couple of months means what? It's couple of months, he's saying, is from his own experience. Whether I can only say that those conditions were to be made. If those conditions were met in 1 month, it would have finished in 1 month. If it would have taken 6 months, it would finish in 6 months.
Let's go back to the chain and have a look at some of the steps that were due to be taken. So if we go, we left off at page 881. So we could open that back up. As we scroll up through this document, we can see we're staying within the same email chain. And we'll go up, please, to page 876. And one can see that this email is from you. This is on the 10th of October 2022. This is to the DFSA to say that we write pursuant to the change of controller approval, and you're updating on the status of fulfilling the conditions. So this is already 3 months later. And you're saying, kindly note below, during the last 3 months, the firm has been working diligently to ensure that the conditions are met. And you're summarizing the actions taken. And if we can see over the page at 877, bullet point 3 is reference to your appointment as director, a resolution to that effect having been executed, which includes the appointment of Amitesh Gahlowt as director. And the status of that is we're going to file the DFSA application and thereafter submit the DIFC application. So one of the steps being taken to effect this change in control was you were being appointed as a director, correct?
Yes, I would say, because that was required as part of the condition on to appoint a director, not necessarily me, but it was proposed and finally agreed that we appoint me as a director. Yes.
If we go to the supplementary bundle at page 62, it's on screen now if you want to look at it, but we can see this is a Banyan Tree Capital Advisors Limited, so parent company, setting out resolutions on the 26th of August 2022. And at the bottom of the page, you can see reference to the DFSA approving changes in control on the 5th of July. And then you can see the list of over the page resolutions, which include removing Mr. Singh at 3, appointing Mr. Vellucci as a director at 4, and then appointing you as a director at 5.
Yeah, correct.
So you would have been aware that there was this resolution on the 24th of August, where
Yes.
your capacity in the firm was going to change, or it had been intended that your capacity was going to change and you were going to become a director. Yes?
Yes.
If we could go, please, to the main bundle at page 897 PDF page number 912. So you can see this is an email chain. The first email in the chain is at the bottom of the page. Do you see it? Friday, August 26th, 2022. Do you see that?
Yeah.
So that's the same date as the resolution saying that you're to be appointed as a director, correct?
I do not note the date of that resolution, but if you say so, I have no objection.
Okay. And if we scroll up to the top of the page, 897, can you see the subject line for the email?
Yes.
The subject line is end of service Amitesh. And this was your email chain, so that was the subject line that you chose, yes?
Yes.
And if we go to see what you say at the bottom of the page, may I request you to share my end of service settlement amount as of end of August 2022. If you can provide the breakup of gratuity, dues, pending salary, notice pay, dues come into effect from February 2020 and my dues has not been paid since August till date. You started with BTML October 2019. So what you're expressly asking for in this email is your end of service settlement amount for the up to the end of August, correct?
Now I would say end of service settlement, and when you're linking up with the resolution, so I need to clarify, and I think it will be better if I can give you a background and to the court. So 5th of
I
July.
think probably what would be most helpful to the court, at least for present purposes, if you answer the question that I asked, which is
I will
whether
answer your question.
this
I will
email
answer-
would.
Okay.
Sorry, may I interject? Mr. Gahlowt, could you answer the question? And if necessary, we can ask Mr. Doherty to repeat it. But then if you'd like to give a little bit of explanation, you may do so. But I think it was a yes or no question, if I'm not mistaken.
Yes. So it's whether you agree that what you're asking for expressly in this email is your end of service settlement amount as of the end of August.
End of service settlement, what are my end of services dues will look like. And I'm asking that in the email. To that respect, yes. But I would like to give an explanation if I may so.
Well, it may well be that at the end, your counsel has questions for you, but I have a list of questions and a relatively limited time, so I'm going to ask those. All right.
Fair.
The specific categories of payment that you're seeking are gratuity, dues, salary, and notice pay. Yes.
Yes.
And if we go back to the email chain, and it might be helpful to just leave the email chain up for the moment. So that's 897 PDF page 912. So we see the next email is on the 30th of August. You don't wait for a response, but what you say is, Dear Amar, so that's Amar from Unitas, to discuss with you, I'm sharing a calculation for my end of service with the supporting documents for good order's sake. My employment should be considered from the 11th of June 2018 for the sake of gratuity calculation, because I know I moved from Banyan Tree, the rep office to BTML. You say I was not paid my gratuity as I had not completed 1 year of employment. Please feel free to do the calculation and present it once you're satisfied, and you attach with the email a document called End of Service Calculation Excel sheet. Do you see that?
Yeah.
So these are calculations that you have prepared, correct?
Yes, I prepared and I shared it with the finance officer for ratification and confirmation.
And what you're expressly telling him that you're calculating is your end of service, correct?
Yes, I'm saying that. Is there,
And
I can explain or
I'll come on to the calculations in a moment. But you can see above that, there's the response from Mr. Azar, and he says, I'm in agreement with your calculations. Do you have that?
Yes.
And I just want to cross-refer that to something which you say in your witness statement. So if you could please go to page 152 and paragraph 83 of your statement. That's page 167 of the PDF. And what you say here is that in both the lead up to the sale of the defendant and after it, you would support the business by preparing calculations showing amounts owed to you and accrued to others, which Unitas would subsequently approve. Sometimes Unitas would prepare them and provide them to me for comment. I did not have the final say as to the amounts due to me at any given point. That responsibility was with Unitas. Some of the calculations I prepared for calculating the apportionment amounts reference the end of service date of employment. You take issue with that phrase being misleading because you never intended it to be determinative of the meaning of the given date. So just pausing there because I just don't want there to be a lack of clarity as to who you say came up with these figures. Presumably you accept, in this instance, the calculations that you have prepared and that end up being approved by Unitas were ultimately prepared by you and not by someone else.
Yeah, it was with the emails that we have seen, it was prepared by me and it was sent to Unitas. But if you allow me now or whenever you allow me, I would like to explain myself there.
Well, I'm sure we'll have the opportunity in due course. What I want to bring you to is the calculations that were attached to that. So 1358 of the main bundle. You can see a series of calculations set out in this page. So this is a calculations document that you prepared, correct?
Yes.
And at the bottom of the page, we can see there's a line which says 49,477. What you're describing as that amount is the final net balance owing to the employee, correct?
No, this is the amount which is due only regarding the itemized items which is mentioned on that email, which was used to prepare this calculation. And to that effect, this amount is correct. Does that mean that it is the entire amount of the sum owed to me? No.
Well, in preparing these calculations, do you accept that you have used the words final net balance owing to the employee and you set out an amount?
Well, I have not used this. This calculator already existed while we were working, and it was only used, and this was more prevalent before the dues regime came in DIFC. So since we were in transition from a regime to a different regime, from gratuity to this was used for all ex-employees, and thereby, because in that email, those itemized requests are made, and I use this calculator, I did not write these final net balance owing to employee or something. I just used this calculator. It was already existing.
Well, Mr. Gahlowt, you accept that these are your calculations, yes?
Yes, I made this calculation.
Yeah, and you accept that you've sent a document which at the bottom of it says final net balance owing to employee, correct?
I send this calculation for ratification, but if you are pointing out to this is the final net balance owing to the employee, which if it involves me, I will say no.
You don't say in this document, these calculations represent a partial payment of a balance owing to the employee, do you?
This document says what it says. What I mean, I'm explaining. It had a particular reason and a purpose why this was prepared, and that mail was being exchanged with Sanjeev or with Amar. And probably I would, if you give me an opportunity, I can explain it now or at the end. But if you mean that this final net balance owing to an employee, which meant it was the final amount owed to me, no.
In your covering email to which you attached the calculations, you didn't say these calculations are a partial payment of the balance owing to the employee, did you?
Partial payments owed to the employee?
Yeah, you didn't say that in your covering email that you sent to Unitas, correct?
Sorry, can you refer it to the email? Your question is that I did not say that it is partial payment.
Yeah, well, we've looked at the email. Let's go
Yes.
back to it if you need to.
Can we
Yes,
go
okay.
back to it so we're all on the same page? Thank you.
897.
Yes, I did not say on that email, but if I can point out, on 26th of August, I sent this that if you can make it. In between, there is a discussion between me and Amar. And I said that if we can help it to prepare these calculations. And there was a discussion which I would love to clarify and bring it to you, to your notice as well. And it was said, whatever it said. So I do not mean that that was a final net amount owing to an employee.
Okay, but you didn't accept that in the email, you didn't say this reflected a partial entitlement, correct?
Yeah, there's not, in this email, it is not said that it is a partial entitlement.
And I'll ask you again, the words that are used in the calculations, we can go back to them if we need to.
Just hold on, please. If I may just go through that email once again, if you can. Yeah, I did not say that it is a partial or something. I did say that please feel free to do your calculation and present it once you're satisfied.
Okay. And if you can go back to the calculations, please, 1358. I'll ask you the series of questions about this. The way that you describe that payment at the bottom of the page is that it's the final net balance owing to the employee, correct?
Yeah, this reads final net balance owing to the employee.
And if we look at some of the content of what this includes, for example, end of service gratuity at the top, that's an entitlement which, as the name suggests, is normally paid to you at the end of your period of service, isn't it?
Yeah, in normal circumstances, yes.
And an annual leave cash out. So that would be claiming for days of leave which you say you haven't used. Yes?
Yes.
So that's the sort of amount of money you would claim when your employment comes to an end and you haven't had the chance to use the leave yet, correct?
Yeah, correct.
Notice pay. You don't get paid notice pay, do you, unless your employment is being terminated?
Yes, you're right. It doesn't happen. But if you allow me to clarify now, or probably towards the end, I will clarify.
Let's have a look at the supplemental bundle, please.
Just one moment, Mr. Doherty. I just want to explain, Mr. Gahlowt, when your cross-examination is finished, you will be asked some questions by your counsel. And if there's anything at that stage that you wish to explain or that you've indicated you wish to explain, your counsel can ask you questions to give you an opportunity to explain. Okay?
Thank
Yes,
you.
Mr. Dodge.
So page 205, there of the supplemental bundle, there's a document. It's sideways, but I'm sure that we can rotate that once it's up on screen. These are documents which you disclosed relatively recently. One can take it, I think, but I'll just ask you from the face of the document, but these are calculations that you have prepared at some point in time prior to November 2022, correct?
I don't think so. It's November 2022. With the
We
color of.
don't know the date. What I'm asking you is, you prepared these calculations,
Yeah, I
yes?
did prepare. Yes, yes.
And in preparing them, you see that the form of this is, it says schedule of full and final statement, yes?
Oh, yes.
You will have known that the purpose of providing these calculations was to reflect everything you were claiming to be due and paid up to the end of your service, correct?
No.
And in fact, if we look at where this formulation comes from, go to page 481, please, of the main, I believe, the main bundle. These are documents that you provided along with your witness evidence. I think you make the point in that from time to time you would prepare calculations. We can see that this is a letter sent to another employee, and you see the subject heading is termination of employment from Banyan Tree. Can you see that?
Yes.
And if we go to page 483 from here, do you see that document appended to this letter,
Yes.
which says schedule of full and final statement? Yes?
Yes.
When calculating your own dues, you have used exactly the same template that you would have expected and which in the past you had used when calculating termination entitlements of other employees.
Yes, I've used the same template.
If we could advance slightly further forward, please, to page 918. Here you can see this is the 17th of October 2022. It's sent by you to Mr. Singh, copying in a number of individuals from Unitas.
Yes.
And we can see as we scroll down this, you say, apologies for the delay in responding. You've been checking all the transactions from May 2021 until today. You say, as requested by you, find attached this email, and you make reference to the bank statements from Citibank. That's for the company. And at the second bullet point, you say, the calculation of the amount due to me, this calculation was checked by Amar on the 31st. So that's looking back to the emails we'd already seen. And what you're saying then is, I've just added for the month of September and October 2022. If required, Amar can recheck the calculation. So what you've done here is you've taken the calculations we've already been looking at, and you've added on September and October 2022, yes?
Yes.
you don't say that this is a partial payment of the amount owed to you, correct?
It doesn't read that it is partial payment.
And you can see at the top of this email chain, there's a list of attachments. Can you see that? So that's some supporting documents.
Yeah. Yes.
And the last one is a document that you have titled End of Service Calculation Amitesh Gahlowt. Yes?
Yes.
Do you agree, given what you say about including the month of September and October, that this calculation isn't just for payments up to the 5th of July, correct?
This payment is?
It's not calculated up until the 5th of July. It's calculated up until October 2022.
No. 5th of July, what you're talking about, because it is not including my past due salaries, it is only including certain itemized item which I have not been able to explain. And that's it. So does it mean that it includes all my past dues and everything? No.
Well, let's look at what it says. You say it's the calculation of the amount due to me. So what you're telling the readers of this email is this is your calculation of the amount due to you, correct?
I would like to point out over here that this email is to Mr. Sanjeev Singhal, which he had asked me to prepare and it is 17th of October, how the discussions were spanning out at that point in time. So I'm going to say, sorry, so I wanted to just highlight this and you can ask me the question.
That's okay. That might have been an answer to a question. I don't think that was the answer to the question that I asked. What I'm asking you is whether you agree that what you are saying in this email is this is the calculation of the amount due to you checked by Amar. Yes?
Yeah, this amount has been checked by Amar.
We've already accepted that you'd say that you do not say that it is a partial payment, but the question I was asking you immediately after that was if you agree, given that you say I have added the months of September and October, that this is not a calculation which only goes up until the 5th of July, is it?
Yeah, this only refers to the dues payment. I have only added the dues account, what do you say, a regularization for October and September and October. It doesn't mean that it includes all my entitlements or amount due. And that too, it's September and October because it started from August and we were not sure how the apportionment will fall through and what will Sanjeev will pay from their capital account to my account.
Okay.
Yeah.
You break that down. You don't say any of that in this email, do you?
Yeah, it is not said, but it is understood by everyone.
Well, what you do say in this email is I've added the months of September and October. I've asked what I think is a relatively straightforward question about whether you agree that these calculations are not just up until July.
Yes. Okay. Yes.
Okay. If we look at the last paragraph before the table, where it says the day capital is infused by Enzo and funds credited to the Citibank account of BTML, we can execute the outward transfers. Do you see that?
Yes.
And if we can go down to the next page, we can see that there are two lines right at the bottom which say total due to Amitesh, which is D plus E plus F plus G plus H, which you've defined again then as letter I when you add them all together. Is that what that means?
Yes.
Yeah. And to be clear, the constituent elements of that, do you agree, are, I'll do them one by one just so that there's no room for doubt. One, it's your gratuity up until January 2020. Yes?
Yes.
It's payments towards dues up until October 2022, correct?
Yes.
It's leave encashment up until October 2022, correct?
Yes.
It's 1 month's notice pay as per DIFC employment law, yes?
Yes.
And we've got the sum of $7,500 for work due to Amitesh for work done on withdrawal notice, correct?
Yes.
So all of those equal I, and the structure of this payment is that whatever is due to be paid to Sanjeev, the amount owed to you will be deducted from that, correct?
Yes.
So the more money that you're owed, the less money Mr. Singhal is going to receive from the company.
Yeah, from the capital that was retained. Yes.
Just pausing on the work done on withdrawal notice, I think you accept that prior to this point in time, the company wasn't actively trading or carrying on any business, correct?
The company was an ongoing company. Yes, there was a pause in the business, which was informed to the regulators because of certain issues. And we were looking for, at that point in time, for a buyer. So yes, there was no active business that was happening. However, we were servicing the existing clients and ensuring that whatever support can be provided to make those clients satisfied, good, and part ways from the existing company, those works were happening. Apart from regulatory reportings and quite extensive engagement with the regulators, all those works were happening. Yes.
Yeah. So part of what you were doing prior to this time was engaging with the regulators. Yes?
Yes.
And by regulators, you mean the DFSA, yes?
Yes.
The withdrawal notice, that relates to the DFSA's attempts to withdraw the company's licenses to provide financial services, doesn't it?
Correct.
So for that work, which you've been providing to assist with regulatory issues, you have set aside a specific sum of money of $7,500, correct?
Oh, yes. From the calculation perspective, if you're referring to, yes, for the work done there. Yeah, because it has gone to Sanjeev. I can explain. Yes, it is, but yes.
So you're saying that's not work done in your capacity as SEO of the firm?
No, I'm saying it is work done by me as a capacity.
I'm sorry,
I'm not denying that I did not work for ratifying the withdrawal notice.
You got paid separately an amount of money in connection with work done on the withdrawal notice. That's what this reflects, yes?
Whether it was separate, it was part of apportionment of the cost, because if I give you the complete picture, you will be able to understand that. So I would say whether it was amount owed to me and paid separately for the work, I would say no. It is part of my dues that were there. It was named as work done for that, and I can explain why it was mentioned like that.
You have agreed with Mr. Singhal an amount of money that you're going to be paid for the work that you've actually done, and that's what's reflected in this table, yes?
Yes.
If we can go, please, to page 885. And forgive me, Your Honour, I haven't been keeping that close an eye on the time. I realise we're not necessarily on timetable, but if there is a point at which you need me to stop, or within sort of 15 minutes, I can pick an appropriate moment.
I thought we might keep going for another half an hour till 1:15 p.m. UK time. Is that going to work for council?
Yeah, that's fine from my perspective. I will let you know if there comes a natural break around that time.
Of course, please do. And then I'm hoping we could take a slightly shorter lunch of 45 minutes. And then if we came back theoretically at 2 p.m. UK time, do you have an idea of how much longer you might need?
I will probably be able to give you a better steer on that when we come back from the lunch break, because then I can
Sure.
look at what's ahead at that stage.
Sure. Okay, please continue.
You go please to page 885, which is 900 on the PDF numbering. This is an email that you sent on the same date as the email we've just looked at to Mr. Singhal.
Yes.
And here you say, "Dear Enzo, I've shared the working cash flow with Sanjeev." That's what you just looked at. This was to give him clarity of the amounts due to him. And you're sharing the same with Mr. Vellucci. You say here, my dues till 5th of July will be paid by Sanjeev. After that will be paid by you. Again, I'll ask you this question because I've asked it in the context of the other email. That's not correct, is it? Because we looked at the calculations that you provided to Mr. Singhal and they went up until October 2022, correct?
I clarified that time that it only pertained to the dues calculation. So the month mentioned, September and October, it was just to include the dues contribution for that calculation in that particular mail. It did not mean for the entire amount that was due on the defendant.
Bear with me, Your Honour. I think this, just please go back to it because I just need to ask you a follow-up question about what you said there. Go to page 919. That's 934 of the PDF. So I'll just repeat that in case it was missed. It's 919. Thank you. So can I just... Oh, yes, all right. So if you look at 919 at the table, due to Amitesh towards dues payment account from the 1st of February 2020 until October 2022. Do you see that?
Yes.
This is the email to Mr. Singhal. It is not correct what you say that the 5th of July date refers only to dues, is it? This payment is up until October 2022.
Yeah, this dues payment is up till October 2022. That's true.
Okay. Well, let's go back to your email to Mr. Vellucci, please. So that was page 885. So in this table, you've set out ABC, so the amounts payable to Mr. Singhal. You don't set out here, do you, the breakdown of what you're receiving, correct?
Yes.
What you do tell Mr. Vellucci, if we look below the table, you say above amounts are after deducting my dues that would be paid by Sanjeev, correct?
Correct.
So you're telling Mr. Vellucci that the amount that he is going to pay to Mr. Singhal is net of what you're owed. Yes?
Net of what Sanjeev owes to me or has agreed to apportion the cost. I would like to clarify that it does not mean that I have included all my dues in this calculation to Sanjeev and it has been paid.
You don't say in this email that it reflects a partial payment of what you're owed, do you?
No, I don't say that it is a partial payment. I say above amounts are after deducting my dues, that will be paid by Sanjeev. I do not say all dues.
You don't say in this email that you were still owed in excess of $200,000 in unpaid salary, do you?
Well, it was not in excess of $200,000 at that point in time when we are talking about. It is October of 2022, 17th October. So why will I say that?
You don't say in this email, in fact, that you're owed anything in addition to what's going to be paid by Mr. Singhal, correct?
Sorry, can you repeat the question?
In this email, you don't say anywhere that there is any outstanding amount that will be owing to you after Mr. Singhal is paid, correct?
Yeah, I'm not mentioning that. I'm just saying that out of my dues, what is being paid by Sanjeev. That doesn't mean all the dues on the defendant is wiped out.
In your own witness statement, you refer to the intention in making these payments was to create a blank slate, correct?
Well, blank slate was in effect, and what I meant is to regularize things. So from the effect of dues account being regularized because Sanjeev had agreed to pay those amount of the dues, yes. Does that mean that I have wiped out all my dues? No. You can't wipe the slate blank by just not recognizing and wiping it completely. You have to do the proper thing, and then you consider that it is at square one now to move ahead.
You knew when these payments were going to be made, whatever amount was paid by the defendant to Mr. Singhal was going to depend on how much you were going to be paid. Yes?
Whatever amount is being paid by defendant.
Let me put it this way. Whatever amount of this sum of money in the bank accounts and due under the SPA, whatever amount is going to go to Mr. Singhal is going to be reduced by however much is paid to you.
Okay, if I can clarify from my memory and my understanding, as per SPA, the amount was to be paid was $100,000, which was amongst all these things renegotiated because mentioning that it has so much delay and everything. To effect, there was no mention about what bank account and capital will be paid. However, there is a mention of how the apportionment of cost will happen after that SPA is in effect, and thereby how the cost will be dealt by and how it was dealt. There's a lot to be explained in that. So if you're saying that I am writing off all the dues that I had towards the payment that is being made in these calculations by the defendant and it is going through, I don't think so it's correct because there's no mention in the SPA about the capital amount and everything.
Yeah, and the question I asked you is different. You knew when you sent this email to Mr. Vellucci that the amount that you were going to be paid was going to be deducted from whatever amount was going to go to Mr. Singhal, yes?
Amount that will be paid to Mr. Singhal will be reduced for the amount which is owed by Mr. Singhal to me, which he has agreed as a part of apportionment. Yes.
Yeah. So if Mr. Singhal was owed 250,000 and you were owed 100,000, then Mr. Singhal would have got 150, yes?
Yes.
And if
I was
Mr.
owed
Singhal
from
was
Mr.
owed
Singhal. Sorry, I would just like to make a correction there. If I was owed $100,000 based on the understanding from Mr. Singhal, then this calculation which you're suggesting? Yes.
And if Mr. Singh was owed $250,000 and you were owed $250,000, the payment to Mr. Singh would have been zero.
Yeah.
We look at paragraph 76 of your witness statement. That's at page 150. At the bottom of the page, you say, as with the sale of any business with employees continuing, it's common for the buyer and the seller to agree how employees' entitlements will be apportioned between them. In this case, due to the failure of the defendant to pay my entitlements at various points, which was flagged to Mr. Vellucci prior to completion of the sale, I assume that the parties to the sale of the defendant would have been even more conscious of such apportionment. So you will have known at the time you sent these emails that this issue of the apportionment was important to Mr. Vellucci when he decided to assume control of the company, yes?
Of course, it was important. And that's why it was raised again and again.
And what you have told Mr. Vellucci in the email that we've just looked at is that your back pay issues were being settled by Mr. Singh, correct?
Not all of the dues. In the context and with the discussion that was happening, I had to take my dues, what Sanjeev has agreed, from the capital that is there before it moves out. That doesn't mean that I was telling Enzo that all my dues are paid by Sanjeev.
Let's even take it on face value. I've already asked you about the 5th of July, but what you say is my dues till 5th of July will be paid by Sanjeev. What you're telling Mr. Vellucci in your email is that everything owed to you up until the 5th of July was being paid by Mr. Sanjeev, and that was going to be taken off the amounts paid to Mr. Sanjeev.
Okay, so there is a background to all these discussions and the email that has been put. I'm going to say, if you go by SPA, my apportionment had to happen from June of 2021. Then October 2022, there is an email wherein the discussion is happening. I'm going between Sanjeev and Enzo to pay my dues and pay my wages and pay my salary. And then we reach to a stage of approval being received from DFSA, and we are kind of discussing who will bring what and when the capital will be infused. And then Enzo is saying outrightly that forget about the past dues completely and please discuss with Sanjeev. When I go to Sanjeev, Sanjeev says, I will honor you as per the SPA and I will treat you in the same way I have treated all my parting employees. So you do this calculation, whatever it apportion to it, you can apportion however you want to, and you take those money. So when you're talking about the 5th of July, there are many discussions that has happened in between, and that if that amount is being cleared till 5th of July, no, it is not. And that 5th of July has come into existence because of Enzo's adamant stand that I was not the owner of the company and I should not be bearing any of the operating expenses of the company, which was not the reality. He was paying all the operating expenses of the company since June 2021. He signed the SPA. So what I had to do, I'm going to say, okay, you recognize at least the approval that has been received from DFSA that, okay, this has approval come through and I'm the owner, which he did not recognize as well. I'm going to say I have never been paid anything from him, even from 5th of July, which probably I'm being questioned at this point in time.
Well, I think what you were saying is you were having discussions, you were trying to come to a resolution. Ultimately, what you have led Mr. Vellucci to believe here is that the payment that was being made to you was creating a blank slate. It was clearing the dues owed to you up until that point in time. That's what your email says.
No, that email says that, and it is not believed. If you see all the accruals that is happening after that. I'm going to say I was not the only person working there. There were compliance who advised Mr. Vellucci. There was finance officer was there. We had all regulatory requirements. I'm going to say if Mr. Vellucci had a confusion, it could have been clarified rather than left in the limbo and being now I am answering that I made a representation. No, I did not make a representation at any point in time, any further discussion that I had with Mr. Vellucci that I'm writing off all my dues. Yes, there were negotiations and there were discussions. I was being reasonable, but were I writing off all my dues? No.
And just to put these discussions into the context of this claim, so first of all, can I ask you to go to page 974 of the main bundle? It's page 989, the PDF.
Mr. Dorothy, I would just like to apologize. Probably I'm raising my voice. Please excuse me for that in explanation and explaining myself.
You send this email on the 21st to Mr. Singh. This is the proof of payment. And presumably you would accept that the flow of funds or the sets of payments that were described by the emails we've just looked at were made.
Sorry,
they might have been,
they
were
made,
made
yes.
of November, yes?
Yes.
And if we could go, please, from there to page 13, which is your particulars of claim. That should be page 28 of the PDF. We can see in the third, this is the amounts that you're claiming in these proceedings, and you can see the third row says gratuity payment just under $14,000. Do you see that?
Yes.
That's an amount that you had already calculated, claimed, and been paid in November 2022, correct?
The calculation, yes. I was paid that amount, and how it was apportioned in the books is something a different story. I'm going to say it was because Sanjeev had agreed that, okay, you do these calculation and I will treat you in the same way how I've treated my past employees. Do these calculations with that respect. Yes. If you say, if I agree to that, yes, I received that amount and it reduced the liability of the defendant by that much amount.
Well, you're the person who provided the calculations. You provided what you say were gratuity payments, which you say were ultimately paid by Mr. Singh. So the amount that you're claiming in these proceedings, you have already been paid as a matter of fact, yes?
Because it was apportioned towards my due salary. So based on what accounting has happened and what has been produced to everyone, and whatever claim I have brought in, whether it is when I've asked for producing what is the age payable, what is the due amount, I have always depended on the finance officer of the company. And if they needed any clarification, I have provided to do the adjustment. So all of them are there and have been shared. Yes.
We'll come back to how you recharacterize it later on when we get there in the chronology. But if we look also in this same document, unpaid wages in lieu of notice period, you have already been paid in November 2022 amounts of money in lieu of notice, correct? That was part of your calculations.
Okay, if you say yes, but I need to clarify these.
Nowhere in any of the emails that we've just looked at did you seek to suggest to Mr. Vellucci or to anyone at Unitas that the company still owed you unpaid gratuity, correct?
Sorry? Can you repeat
There's
the question?
nowhere in the emails that we looked at which said that after those payments were made, the company was still going to owe you amounts for unpaid gratuity.
Yeah, we haven't seen an email where I have sent that to the finance officer. Or
There's nowhere in the emails that we've looked at where you tell Mr. Vellucci or anyone at Unitas that even after the transfer is made to Mr. Singhal and to you, that you would still be owed unused holiday pay from 2022, correct?
yeah, there is no mail like that.
And there's nowhere in any of those communications which precede the payment being made to you in November 2022 in which you suggest to anyone that you're going to be owed substantial amounts in unpaid salary, correct?
That was already understood and known to everyone. And that's how the conduct has happened. I mean to say, post November, end of December, there was a capital breach. There were regulatory filings. Then there has been external audit, and that regulatory filings on a quarterly basis have kept on happening on that particular thing. So how do I make uh, a representation that okay, this is not due? They knew what is due, and that's how it was conducted.
I'm going to rephrase and re-ask the question so I can get an answer. But you have not exhibited to your witness statement any communications with Mr. Vellucci in which you said, after the payments are made to Mr. Singhal, the firm will still owe me unpaid salary.
Again, I will say that it was understood. Why will I have to specify this separately? I'm saying that I have taken the amount from Mr. Singhal, which has gone from the capital that was there from him. I am not writing off all my dues. Whenever, if you're talking about email, no, but I have been having many discussions with Mr. Vellucci. I had in December, then when he's saying that I made an offer in January, which I don't remember, in February, finally we do not reach an agreement and I have to bring it to a claim. So on email, no, but in conduct, in discussion, in everybody's knowing and understanding, yes, everybody knew that this is owed.
Have a look very briefly at supplementary bundle page 86. We can see there's an application to vary an authorized individual submitted to the DFSA. Over the page, if you look at the top, there's a submission date here of the 22nd of November 2022. So that would have been the day after the payments were made, correct?
Yes.
And if we go forward to page 90, at that point in time, with effect, it says from the 26th of October 2022, your status as SEO is to change from being a senior manager to a licensed director, correct?
Yes.
Your Honour, that's probably a natural point I've come to. I'm about to move on to a different topic, which will consume some time, so it might be a sensible place to pause.
Thank you. Let's take a break and let's reconvene at 2 p.m. UK time, which I understand, just trying to figure out my timings, which I understand will be 5 p.m. UAE time. And Mr. Gahlowt, you're still under oath and giving evidence, and please don't discuss your evidence with anyone until you've completed giving your evidence. So we'll see everybody back here at 2 p.m. UK time. Thank you.
Thank you.
That's it.
Wonderful. So we will now continue with the claimant's cross-examination by Mr. Doherty as soon as we see him back on screen.
Apologies, I hadn't realised I was off.
Right, you said you might have an update on timing at this stage.
Yeah, I mean, I suppose very proficiently, I think started later than expected. I think I've been going about 1.25 hours. I probably have about 1.5 to 2 to go. Based on
Okay.
start to get going and see.
I understand. Okay. Let's continue. Thank you.
Thank you, Mr. Gahlowt. I wanted to move on to have a look at some aspects of your role, following on from the change in control process. I just want to start at page 160, which is 175 on the PDF. Going to your witness statement. And specifically paragraph 111. Which, when it comes up, it's the extract which makes reference to your being in Cairo and then in India during December 2022. So you say you flew to India from the 19th of December to the 26th of December 2022, and Cairo prior to that from the 10th of December 2022 to the 16th of December 2022. You're correct. I think what you suggest was a mistake on the booking form that said you were in Cairo until January. And the point you make is that you say you worked remotely on all working days. You did not request to use, nor did you use any of your holiday entitlement in 2022. I have some questions for you about that. And if we can start, please, at page 726. This is a WhatsApp chain you refer to and rely on at paragraph 72 of your second witness statement. You say this is evidence that shows you were employed by the defendant. And I'm specifically looking at on the 5th of December at 2:35 p.m. So this is at the bottom of this page. The last 3 lines, she says, "Hello, Amitesh. I hope you have a great holiday." Do you see that?
Yes.
So this is on the same week. So I've gone to check. The 5th of December is Monday. On the same week, you're going to fly to Cairo on the Friday, on the 10th. And Karen says to you, "I hope you have a great holiday." Yes?
Yes.
The explanation I think that you provide for this is to refer to UAE national holidays, National Day and Commemoration Day. But those were the week before, weren't they? That was the 2nd and 3rd of December. Yes?
Yes.
She's not saying, "I hope you had a good holiday," or "I hope you had a good commemoration day," is she? She's talking about the future. She's saying, "I hope you have a great holiday." Yes?
Yeah, okay, yes.
You don't correct her at that point and say, "Actually, I'll be working remotely as normal, so I'll be speaking to you while I'm overseas." Correct?
I'm going to say in the following message itself, it says that please is registered and I assume the card is ready. She's asking me a question. So while I would be away, I would be still looking into what things needs to be concluded and to be done. If I have to just go by these messages and what you're saying, did I take holiday? Yes, I did take holiday at that point in time, and I did travel to Cairo and to India. It was in December. Most of the things were in line and it was in process and happening. So yes, maybe a couple of days. Were I not engaged in completing the work? No, I was, and I was responsive on during those time as well.
So is your evidence now that you are taking holiday and these periods of away in Cairo and India are holiday?
I think I've already shared that I was away for those periods. there, but holiday, if you mean I was away, yes, I was away. Was I responsive when I was working? Yes, I was working.
I mean, you must know that the reason I'm asking you about this is because your claim is for unused holiday entitlements. And what you said in the witness statement I've just taken you to is I worked remotely on all working days. I did not request to use, nor did I use any of my holiday entitlement in 2022. So can you please tell us whether your case today is you did take holiday or you did not?
Was I away from UAE? Yes, I was away from UAE, but I was working when I was away in terms of whatever limited work was there, and I did respond to them. Yes, I did that. If you want to consider it as a holiday, I'm going to say it's absolutely okay to consider that as a holiday.
Well, this is your claim. You tell me, are you claiming accrued but unused holiday pay in this window or are you not?
Yes, I am claiming my accrued holidays.
And you're maintaining that claim?
Yes.
And the basis upon which you're maintaining that claim is what? Because you say you were available to work remotely all days.
Yes.
Okay. Can we open 727, which is part of this WhatsApp exchange? In the middle of this page, first of all on the 6th of December, but then it goes into the 7th of December, starting on the 6th at 4:06 p.m. Karen sends a message saying, we should have access to the building. As for parking, Elena sent you already the car plate number right. You respond to that on the 6th. You say, can you share the car plate for parking access? And on the 7th, she sends you car registration plates that she wants you to get access for the building for, correct?
Correct.
So in this exchange, you are being asked to sort out parking permits effectively, yes?
Yes.
And if we go, sorry, just pausing there. So this is on the 6th of December. This is after Karen has said, I hope you enjoy your holiday. But your evidence would be at this point in time, you're ready and available for work, yes?
Sorry, can you come again?
Well, Karen has said to you, I hope you have a good holiday.
Yes.
Your evidence in your statement is that you're ready and available for work and that this isn't annual leave, yes?
Yes.
So your position presumably is you would have responded to this request and done what was asked of you, yes?
Yes.
Go to 7:30, please, on this same document. And if you look at the top third of the page on the 6th of February 2023 at 3:30 p.m., Karen sends you a message, hi Amitesh, boss is asking for his parking access for DIFC. Do you see your response below that?
Yes.
You say, oops, I will apply.
Yes.
Yes?
Yes.
So in this period of time when Karen's saying you're on holiday and you're saying you're ready and available for work, it certainly would appear here that you have not followed through on the request to sort out the parking, correct?
Okay.
Do you agree?
This is not agree. No, I don't agree.
Well, this is 2 months later, and it seems as though you haven't sorted out the parking and you say, oops, I will apply. So 2 months after the request is made, you still haven't done it, correct?
Well, it didn't happen because there are many things when a lease is applied and a parking can be assigned. It is not only signing the lease agreement. The lease has to be registered with the IFC authority. Who will register it? There is back and forth on that. That happened. And thereafter, yes, there would have been some delay in applying for parking access because I had the access on that, and any parking would not have been allocated because the lease was not registered with the IFC authorities. That's what I can remember from my memory. What was the reason for this delay? I don't have the documents in front of me at the moment.
But you will accept, presumably, that this was not sorted out in December when you were in Cairo and when you were in India.
Yeah, while those days when I was not there, probably yes, it was not sorted out at that point in time.
Go to 727, so backwards in the same document. And below the exchange that we've just looked at, you can see this is on the 20th of December, 2:11 p.m. Karen says, "Hello, Amitesh. How are you? Can you please send me all the Banyan Tree legal and corporate documents? Enza wants them in her office files." And she gives you her email address. Do you see that?
Sorry, can you just tell me the date and time once again?
20th of December,
Yes,
2:11.
yes. Yeah.
Yeah. So she says that Enzo wants the corporate documents. That's what she's requesting you to provide, yes?
Yes.
So this is the 20th of December. This is one day after you've flown to India on the 19th, yes?
Yes.
And you're due to fly back on the 27th, yes?
Yes.
And below that, you say, we'll send to you by 27th. Do you see that?
Yes.
So what you've told Karen is, I will give you the documents when I come back from India. Yes?
Yeah, probably yes.
When you're back from your holiday. Yep.
Yes.
It's not correct, is it, that you were remote working during this period? There have been 2 requests made of you, none of which you have carried out, correct?
Yes. So you were saying, I need to clarify here. When I'm remote working, I'm responsive on everything. So I'm giving a response that I will provide you by 27. That doesn't mean that I'm saying I will not provide you these documents. Those documents and those applications could not have been made at that point in time. For parking car, lease had to be registered. For the corporate documents, it was not handy with me on my phone. It was on the computer that I was using. So it will be provided when I'm back.
Yeah, so your evidence that you've given is that even though you're abroad, that you are working remotely on all working days, you did not use any holiday entitlement, you've been requested to provide corporate documents, and your answer now is that you weren't in a position to provide those until you were back. Yes?
Yes.
And I've suggested to you that it's simply not correct that in this period of time, when you were in Cairo and then when you were in India, you were not remote working.
Okay, if with this incidence, if you're talking about I'm not remote working, or if I cannot respond, or I'm not looking at the emails, I'm going to say I leave it to your judgment. But I was always accessible while I was away for any critical matters.
Also there, Mr. Gahlowt, this is the 21st century. It's not uncommon for senior employees to go abroad and to monitor their emails. That's not what I'm asking you. What you have suggested in your evidence is, in effect, I was ready and able to work. And as I gather it from the evidence you just provided, when you were in India, the reason you couldn't send the corporate documents was because you didn't have your work laptop to do it.
Yes.
Right. If we look at the bottom of this page, the very last line, you can see Karen writes to you on the 2nd of January. Do you have the documents I was asking for? So actually, in fact, you don't provide them when you're back from India on the 27th, do you?
Yeah. Okay. 20. He's asking me again. Yes.
Yeah. The reality is that you're receiving these responses. You're abroad, you're in Cairo, you're in India. And in reality, you're responding to these requests at your leisure. That's right, isn't it?
You can go back. If I can see that message again.
And sorry,
Yeah.
can I interject here? If we're going to ask a number of questions relating to one document, can we just please keep the document up on the screen? Thanks.
So why do you say I was not responsive?
Well, you were asked for these documents on the 20th of December. You didn't provide them then when you were in
Yes.
it. Agreed?
Yes, which I
You said you
explained because
provided-
it was not available with me.
Yeah. You said
Yeah.
you'll provide them by the 27th. That's what you said, but you didn't do that, correct?
Yes.
And you've had to have a follow-up again on the 2nd of January saying, can you send these documents that the owner of the company has been asking for, yes?
You have the documents I was asking for last time. Okay, so I don't foresee in this because it's on a WhatsApp. There has been in a normal course of business, even with Karen, when I had to follow up on multiple things. So I'm going to say if you want to put a blame on me that I was not responsive, I would say no, because from 27 to 22nd of January, I have been kind of in touch with her and providing whatever is required. And if she's asking for the change documents or thing, because I remember I've shared a set of documents sometimes before that, the existing set of documents. By this time, 2nd of January, I had no new set of documents to provide to her. So I would have either clarified it further or spoken to her or something like that.
Well, let's look at how you respond to her when it comes to some of the other requests that she's making in this early part of the new year. So at the bottom of page 728, so over the page, there's some exchanges between you in relation to these corporate documents. At 7:07 p.m., sorry, we'll start just above that, 7:05 p.m. There's reference, this is the 3rd of January, 7:05. Karen says Edwin will be there too. Edwin, I think that's the person we looked at who took over the role of SEO eventually. Is that right?
SEO of, he was associated with Neovision Ventures, from whom Coinvesting was leasing its place.
Yeah, and would eventually be the SEO of Coinvesting, yes?
I was not aware at that point in time.
But she's saying that she has a question about paperwork. She's needs to do a checklist of what's done and what's not done. Below
Yes.
that, you sent me the old paperwork. I need to know what are the paperwork we're waiting from your end, what's being processed, what's pending. Below that, she says we also don't have access cards and parking cards. And this looks like a mounting body of work. She says there's really a lot of things. And when Anzu was asking me, I don't know what to say. She underneath that, she says all his businesses, I have all the paperwork and I know what's missing and not, except for Banyan. So I need to sit with you so that I will know what's missing, what I need to follow up, etc. So in that exchange, Karen is telling you, I want you to come in to sit down with me and run through all of this. Yes?
Yes, that's what indicated. Probably if I can go back further, because there's a communication. So I hope everything is provided here. So if you can go back further as well, how these are clarified, I think it will give a clear picture.
Yeah. So she's asking you to come in for a meeting, yes?
Yes.
And your response below is, I'll update you. If needed, we will meet. That's what you say in response, correct?
Yes.
So your position is you're only going to meet her if you feel it's necessary, yes?
Of course, yes. If it is necessary, if it is required, we'll meet.
If we look at the bottom line, she tries again. She says, we need to meet because I need to finish all the paperwork checklists for the DIFC. And she adds, there are projects we are investing and they need paperwork from us. So she's telling you here, there are two things she's seeking this meeting for. One, it's to deal with the administrative side of the DIFC, but also she's telling you there are projects we're investing in and we need the paperwork. Yes, that's what she tells you.
Okay, so well, yes, what she's telling me is here. I think you have added some comments over here. The administrative side, she was not dealing. She was following up, maybe to feed into Enzo what is pending, what is not pending, what has happened and what has not happened, because she was working on a day-to-day basis with Enzo directly. Administrative work and paperwork. Yes, she wanted the paperwork. I have clarified earlier as well. By 3rd of January, there was no new set of paper that had got generated. We were applying. So lease was to be applied. After the lease is registered, the address had to be changed. We had to apply for amending the articles of association, the shareholders capital that was infused, the shareholding had to be infused, new documents, those documents had to be provided to the bank. So there were many lists, and I think I provided.
I'm not asking you about documents. She's asked you at least twice now for a meeting, and you've told her, I'll meet if needed.
Yes.
She repeats it, and she says, this is for paperwork for the DIFC, but also projects we're investing in. They need paperwork. And if we go over the page again to 729, and if you look at her message at 725, she says, if not tomorrow, we can meet Thursday. So she's asking you again for a meeting, isn't she?
Yes.
And your response to that is, after the checklist, if still needed, we'll meet. Yes?
Yes. I will share the checklist to follow. Yeah. Yes.
You're treating your role here as something to be done at your convenience, not at Karen's request.
No. I am sharing the checklist and I'm giving an offer that if needed, I will meet you. That's my offer is here from very clear.
Karen couldn't have made it much clearer, could she, that she felt she needed a meeting? Yes?
Yes. And I said that what is that meeting for? If that is met, I share checklist and everything, what is to be done. And if needed, I'm offering that I will meet her again. So I don't know why you say so, that I'm not responsive or I'm not ready to meet her.
Mr. Vellucci has provided evidence, and the court's obviously going to hear from him in due course, but you didn't, by and large, attend the defendant's offices at all, did you?
Defendant's office was not ready. Almost, I would say, I can't remember when the lease was registered at the moment, but the lease, I think lease registration has been shared. I can look into the pages and I can tell you. And then the fit out work had to happen. So when he says defendant's office, for a large part from the time we had given up the office, before that during COVID, I was working from home. And whenever need be, we used to meet in person whenever it was required. So I don't know what does he mean by I did not attended single day of office. I have visited his office in JLT. I have visited Unitas office for meeting. I have been available. So if the office of defendant is not existing, what does he mean that I do not attend the office?
Well, this is an example of someone telling you there's important work that needs doing, that they need a meeting.
Karen saying within a period of sorry,
attending that meeting with them. You're pushing back and you're saying, no, we'll only meet later if we need to. Those are your responses to Karen, aren't they?
Yeah, I will meet you if it is required. What is the meeting for? She explained me that she needs a checklist and I'm ready to meet. That's what it's to me.
So on your terms, the meeting is necessary when you think it's necessary, not when she thinks it's necessary.
No, it's not when she thinks necessary. When it is necessary, I will meet anyone, whether it is Karen or Raymond or Enzo or anyone. I'm not saying that it is on the necessity of that. She is asking for certain things for certain reason. I said that I will provide. I don't have the new set of documents with us. If you want to meet me for this, let me prepare the list of checklist what is to be required. If that serves your purpose, even if after that you want to meet me, we will meet. That's what is I'm explaining him. Or probably if you would have spoken over the phone, I don't remember now.
Let's have a look at some of your communications you refer to with another individual, Mark Raymond, at 1129. It's 1114, 1129 of the PDF. And if you look, first of all, in the top half of the page, on the 24th of April, 2023, 3:13 p.m., Mr. Raymond says, how's your holiday? Just want to check if you've got any updates regarding our account login. So you presumably would have understood from this that at the very least Mr. Raymond's under the impression you're on holiday. Yes?
Yeah.
You don't correct him to say, no, don't worry, I'm not on holiday, I'm working from home as I always do. You don't say that.
I don't have to correct him.
And of course, your evidence we've looked at is that you never took holiday. You would have been available and working at all times during working days. But if we look at this request made by Mr. Raymond, just want you to check if you've got any updates regarding our account login. You don't respond to that, do you?
I do not respond.
Sorry, was that you agreeing or repeating my question?
Yeah, I have not responded just after 24th of April. Yeah.
He also, in the next message, this is in the 10th of May, he wants to give you a heads up that they're processing a visa in Coinvesting, and he says, we're not yet removing you as the correspondent, so you might receive updates regarding the application.
Yes.
Now, just looking at those words, we're not yet removing you as the correspondence, and the fact that he's giving you a heads up. I mean, the obvious implication of what he's saying here is that he knew and you knew that you were going to be removed at that point in time, yes?
No.
And if we look at some of the communications that follow from Mr. Raymond during this period, just to give you some examples. So 15th of May at 10:25, he says, hi, Amitesh, good evening. Sorry to bother you. We've received a message from DIFC for our employer application. There's a similar tenor of communication on the 16th of May at 12:16, just below that. He says, hi, Amitesh, good afternoon. Sorry to bother you, as per DIFC. Again on the 16th of May, 4 minutes later, 12:20, Mr. Raymond says, again, can you please forward it to me? Sorry to bother you again. Thank you for your continued support. And just below that, again, 12:41, says, hi, Amitesh. Sorry I was calling you for the update. I know you're busy. Did you receive an email? The reality of this is that he is adopting this apologetic tone towards you because he knows, and you know, at this point in time, you weren't an employee of the company, and ultimately you're being asked to do something as a favor.
No. I'm going to say at the best, what he would be realizing is that I have given my indication that I will move out of co-investing, but I'm ready to support to whatever time period they find a replacement. That's the reality. So why he is apologetic? I'm going to say we need to ask Mr. Raymond. I have not asked him to be apologetic. but maybe he would be knowing how I'm being treated, and that's why he's apologetic, if I say so.
And perhaps if we can address some of these issues even on your own terms, if we look at some examples that you give of the work that you say that you were doing during this period of time. So page 146, which is 161 of the PDF, paragraph 67 of your witness statement, and we'll work through these. You give examples of documents which you say show or evidence the fact that you were continuing to work as an employee for the defendant during this period. And at 67A, you say that there's evidence that shows I was involved in instructing the defendant's auditors, Baker Tilly, and that this was consistent with what you did beforehand.
Yes.
Well, let's just look at the underlying evidence that you refer to. That's at 1168. So 1183 of the PDF.
So yeah.
Yeah, and we'll scroll through this email to see the extent of your involvement. So here's the first email. You say this is on the 30th of April, and it's after 4 p.m. So we're getting towards the end of the business day. You send an email that says, "Dear Mohit, is the plan to submit the audited reports for the year 2022 today? It's almost the end of the day. Have you taken any extension from DFSA? Any explanations to DFSA or fine from them will be on Baker Tilly." So this is the chain you're referring to say that you're liaising with the auditors, yes?
There are many other mails.
And what you sent here at the end of the business day on the day of filing is a single chaser email to check whether the audit's being filed, yes?
Yeah, I have sent a single chaser email because earlier I was marked on all the emails and I was looking into it, what's happening on the audit, what documents are being provided, and I was supervising that and seeing that it is done on time. This is the last day, and if they are working on it on time, so I have sent a chaser to put a pressure.
And if we look at page 1165, we can see, communication sent to you from Mr. Surai at the bottom of this page. He says, "Dear Amitesh, good evening. Kindly provide the balance confirmations for the following accounts." So he makes a request of you to provide something that he needs to complete the audit, yes?
Yes.
And if we scroll up to the next email, page 1164, we can see at the very least, by the time he sends his next follow-up email on the same day, you haven't responded to his request yet, have you?
Yeah, I'm going to say 30th April, what time he has sent that email? Just if you can scroll up.
Yes. He sends an email at 6:27.
Okay.
And he sends a follow-up
Until
email
9:49. Yeah.
over
Because
3
I
hours
would have,
later.
yeah, so I'm going to say if I have not responded and he has chased, it's not that in between nothing has happened. I would have got in touch with the finance officer, the compliance officer to pick up, because all are marked on this email, to pick this email and get the documents arranged.
So you don't respond in the middle of that email. And if we look at 1164, we can see that there's a follow-up request at that point in time. So this is the 9:49 p.m. email. And he says, in this communication, also share the shareholder-related documents requested in earlier trail mail. So that's the previous email we looked at. And he says, going concern subsequent event forms are also attached, for which we need the management's response. Please take them into the letterhead of the company and please sign and stamp from Ms. Remzo. Do you see that?
Yes.
Yeah. And if we scroll up to 1163, we can see that by the time his next email comes in, so this is an hour later at 10:27 p.m., there's no suggestion you've responded to his second request, correct?
Okay, if I have not responded, that doesn't mean that I'm not doing anything behind that. Yes. Yes, I have not responded. Yes.
if we go in this same chain, and we can scroll through it page by page, but if we look at page 1162, we can see that there's a communication. This time it's addressed to Isaac, so that's Mr. Aslam. If we go up to 1160, we can see that there's a response to that, but again, nothing from you yet. 1159 is another email from Mr. Sarai. Again, nothing from you at this point in time. Then at 1158, we get another email. This is from Mr. Sarai again. And he says, thankfully, we've met the deadline of the DFSA. We need to receive the following from your team. And you see there are 2 bullet points there. He asks for 1, going concern form and subsequent events with management's responses. And 2, he wants a letter of representation form.
Yes.
Again, there's no suggestion in this email chain, and we can go up to 1157 to look at it. But there's no suggestion that you've responded to this, is there?
Sorry, your question, please.
You don't respond to those requests. He asks you for going concern form and subsequent events and a letter of representation, and you don't respond.
At the background, I'm having a discussion with the compliance to arrange these documents. So what do I respond on that? It's to provide those documents. So I have to arrange those documents or speak to the person who will arrange those documents. Those are deadlines to be met. So what response do am I not having? Are you suggesting that I'm not engaged with compliance or finance or Mohit himself from Baker Tilly? That's not true.
Well, let's look at 1156. You see at the bottom of the page, there's an email from Mr. Sarai. This is on the 10th of May, 2023. So this is a little over 10 days later from the previous exchanges. And he says, Dear Mr. Amitesh, good evening. Hope you both are doing well. Please be informed that we've been waiting for the LOR, going concern, and the subsequent events form on the letterhead of the company duly signed. So do you agree that by the 10th of May, you still haven't responded to the information that he's been requesting?
Oh, by 30th of May, the audited reports were filed to them. So it's LOR or something that was pending to be signed. It was not clear to me that it has not been provided. So if it was pending, they were following up for the pending documents, it would have been provided.
Well, Mr. Gahlowt, what he said here in an email addressed to you is, we are still waiting on this information, which you haven't provided.
So which had to be signed by Enzo, not by me. And I had asked compliance and everyone to please arrange these documents.
And you don't respond to this email either, the follow-up on the 10th of May, correct?
Yes, I haven't responded, yes.
And if we go, in fact, to 1155, this is now 19 days later, the 29th of May. This time it's addressed to you, to Mr. Enzo, to Isaac, Amar, Dali, and it says, good evening, hope you're doing well. He says, tried reaching Mr. Amitesh, but couldn't. This is a follow-up email. Please be informed that we are still awaiting all that is requested by us from the trail email sent on the 10th of May. Please be informed we have DFSA reviews coming up in our firm. Therefore, we need the LOR, going concern, and subsequent events form to be documented in the audit file. So here we are now, a month after your email on the 30th of April. Yes?
The mail from Baker Tilly to me and to all the people involved. Yes.
And Baker Tilly has sent you multiple requests for information. Yes.
Yes, addressed to me. Everybody is involved. Yes. And if from memory, I can tell that this is on 29th of May. The audited report was due for submission with the extension from DFSA, not extension taken, but was sometimes end of April. That was filed. These were something to be ratified or was not signed up. So they were following up for all these documents to be done, which had to be arranged. I had we had rather finance officer, compliance officer, we all discussed and this was to be arranged and to be done. So that's what this whole mail trail and their follow-up is.
Yeah. And he has followed up with you in this chain multiple times, and you haven't sent a single response to those queries, correct?
Yeah, I haven't sent a response, yes.
To the point that a month later, he sends an email saying he's been trying to reach you, but he can't, correct?
Maybe he would have called and he could not have reached me, yes.
And at 1154, we can see that in the end, the person who responds to this is Mr. Aslam, correct?
Yes.
And this is documentation you have provided with your witness statement, which you say shows the extent of the work that you were carrying out for the company, correct?
Yes.
Let's go back to your statement to look at some of the other examples. So page 147 again, 162 of the PDF. At the top of the page, this is B. And it might be easier if I just read these all to you now, because then we'll go to the documents. But B, you say, I prepared various documents to help Unitas with calculating the defendant's expenses and invoices. C, you say, I supported with the name change of the defendant and associated formalities. And at D, you say, I worked with Unitas to file the FATCA/CRS report. And that Mr. Bellucci was in copy to those emails, but did not stop your involvement until later. So let's work through each of these. So B, the documents helping Unitas calculate the defendant's expenses and invoices. If we could go, please, to page 983. You can see at the bottom of the page, there's an email to you that says, Dear Amitesh, hope you're doing well. This is to remind you that kindly share the bank statement and relevant invoices for the month of November, as we have to file VAT returns this month. So the work you're being asked to carry out here is a single email in which you're being requested to send some bank statements and invoices from November 2022, correct?
Yes.
If we go to page 1101 or 1116 of the PDF, so this should be 1101. This is the evidence you referred to, which say that you supported with the name change of the defendant and associated formalities. So if we scroll over the page, we can see at the bottom that this is an email generated from the DIFC portal, which has been sent to you, which you forward on to Mr. Bellucci and to Mr. Aslam and to Mr. Azhar. So your support in this context, the evidence you provided is forwarding on an automated email from the DIFC portal, yes?
Now, before that, there would have been some work done. What is the name? Which I remember Ishaq would have coordinated with me and Enzo what name has to be done. And he said that, okay, I will make the application. And that application was made. My involvement was like, are we meeting on all the control change requirements? And if that email that it has happened has been received, I forwarded it.
So Mr. Aslam made the application and you forwarded the confirmation, yes?
Yeah, it could have been, yes.
And then if we look at 1182, which is the PDF number 1197, this is what you exhibit to your documents, or to your witness statement when you assert that you worked with Unitas to file the FATCA/CRS report. We can see this is July 2023. You get an email from Mr. Ahmed. He says, I hope this finds you well. I'm writing to inform you that we did not have any reportable financial accounts during the year of 2022. As a result, we will be filing a nil report. To comply with reporting requirements, we'll select the option to file a nil report. And your response to this is say, I'm okay to submit a nil report. Yes?
Yes.
So when you're putting it in your witness statement that you worked to file the FATCA/CRS report, in fact, what's happened is there is no report. This is just a filing of a nil report, yes?
Irrespective of that, there was, of course, it is very obvious that no transaction has happened. That means there has not been no work happening for the change of control and everything. This has been put in somewhere to prove a point that my termination happened in December of 2022. November of 2022. I was involved. And if it was nil report as well, because it was from my portal as myself as the SEO, I had all the right to check everything that are you filing it correctly or not. And that's what I did.
Well, I'm asking you about documents that you have exhibited to your own statement to show the work that you have been doing. And if we look just to complete this chain at page 1215 on 1230 of the PDF, you can see at the top of this chain, there's a response from Mr. Vellucci. And what he says is, as stated before, Amitesh does not work for Coinvesting anymore. Please remove him from your mailing list.
Yeah, I can see that.
So when you've been engaging in this email exchange, you would have known Mr. Vellucci responded saying you don't work for the company, correct?
I would have known. I'm going to say he was saying this from 3rd of July, he started saying this. So I did not agree that I was not there. I'm going to say to prove that point, there are nobody actually, even if I was not involved, everybody is engaging with me, auditors. Even if you're saying that I'm not responding and not doing anything, it doesn't add up that apart from Mr. Vellucci, nobody is knowing that I'm not an employee.
I think you accept in this period of time, none of the activity being carried out has anything to do with, if I can put it this way, active trading in the company.
What
Correct?
do you mean by what do you mean by active trading?
The company's not going to market and it's not doing business. The only things that are ticking along in the background are administration and regulatory compliance.
Administration and regulatory compliance, of course, yes. Filing
Yeah.
of all the returns from the governance perspective to get ready to do the business. It was getting ready to do the business. Was it doing active trading? No.
Yeah.
And which was very much kind of clear and understood that it had to be in a certain shape to kind of commence the business.
And we've looked at some examples of what you say you were doing during this period. And in respect of that, you will have known because you had discussions with him, but Mr. Vellucci made clear to you that he didn't feel the amount of work that needed to be done was an amount that would have justified retaining you on a $13,000 a month salary, correct?
I'm going to say that discussion, that amount of work, no, he just had one statement. This amount of explanation never happened, which you're saying. He said that, okay, I will not pay the same amount of salary that you were getting. It has to be changed. Nothing was agreed. And in the statements, he said that I made this offer in January. Ishaq says that this discussion happened sometimes in November. and it was in October meeting that happened. It was for 30,000 dirhams, $10,000. Whatever number is being said or thrown, nothing was met. That doesn't mean that my employment had terminated and I had given up on all my rights and nothing existed in between.
I suppose setting the dates to one side for just a moment, you at least were aware that Mr. Bellucci did not consider that there was enough work or enough merit in the amount of work that you were carrying out as the SEO to justify paying you $13,000 a month. I'm not asking you whether you agree with it, but that was his view and you were aware of his view.
Yeah, his view has been that on his own. I mean, say, do I agree to it? No, I don't agree.
Yeah. And you mentioned it already. I think you differ on dates, but what Mr. Bellucci says is that in January, he offered you terms, I think you said $10,000 a month to reflect some ongoing assistance. But you'll recall that he did at some point in time make you a different offer, correct?
This offer, to be very honest, there's a background to it. If you want, I can explain that. It happened sometimes in October, November. And first time he mentioned that forget about all your past dues. When we met to formalize the capital flow, the capital requirement, how it will be put in and when it will be put in. And I remember very clearly that when he said to forget about the dues, I said that you can please withdraw my directorship and I'm okay to step down there. And Mr. Sagir Mohammed, which is the name I wanted to correct on my witness statement, he stepped in and said that, guys, we should not do this. We'll look very bad in front of the DFSA. We have really gone back correcting all the things. Let's make this happen and look forward from there. Nobody clarified nothing, and Mr. Bellucci also backed off at that point in time and continued as it was. He said that, okay, I will give you $10,000. I did not say anything. That never happened. He is saying from his memory that it happened in January. I don't remember any discussion that happened in January. I made a follow-up with him in December. Nothing came in.
Let me be clear on what you were saying, because I'm not entirely sure from your answer. Are you saying this discussion did happen in which there was a 10,000 a month offer? It's just that you disagree on the timing, or is your evidence that the discussion didn't happen at all?
No, this discussion happened in the October-November meeting.
In either event, you agree, I think, that you never accepted that offer, yes?
Yeah, nothing was agreed.
So did you say nothing was agreed there?
Yeah.
We've touched on this already earlier in your evidence. This relates to your understanding that apportionment was something which the parties to the sale would have been conscious of. If we could look, please, at page 749. And this is 764 of the PDF. This is going back in time a little bit on this question of apportionment. And it arises from something you said a moment ago, which is you had known that Mr. Bellucci's position was that he considered he wasn't obliged to pay your past dues. That was for someone else to pay, yes?
That was my position, that Mr. Bellucci doesn't have to.
That was your understanding of his position.
It was the defendant that had to pay my due salary, and I was being bouncing back between Mr. Sanjeev and Mr. Bellucci at that point in time to make payment of my wages.
But let me put it, you said in evidence a few moments ago that Mr. Bellucci had said to you, you can forget about past dues. You would have known.
That's the first time in October, November, yes.
Yeah. Before that November payment was made to you, you were aware of a position in which the apportionment of these past dues was agreed was going to be carried by Mr. Singhal, correct?
Yes, which is as per when you speak to Mr. Singhal, he will refer to the SPA that after the effectiveness of the SPA, all operating expenses were for Mr. Vellucci. When you go to Mr. Vellucci, he said that no, your payroll is still with BTAML. I'm still not the owner of it, and kind of denying that I will pay and making an offer that, okay, fine, I will make 50% of the payment.
Yeah, well, we've looked at your emails from October 2022 already. I don't think that we need to revisit that. But let's look slightly further back in time in relation to the discussions that you had with Mr. Singhal. So this page 749, we can see it's an email from you to Mr. Singhal. This is copying in Mr. Aslam. And you say at the top of this, with reference to our discussion on remuneration, in good faith, I agreed I'll support you till March 2021. You go on to say, I've been delivering my duties and responsibilities, but you're not being remunerated. And it's only fair for you to expect that. You say you had a similar discussion with Mr. Vellucci, the buyer, and he's of the opinion that payroll is still with BTML and he's not owing, so it should be paid by the existing owner. You refer to a verbal agreement made at that time about sharing it, and you're asking for the consent of Mr. Singhal, which I think is common ground he doesn't provide, to share that. But the question I have for you, reading this email, one, it's clear, isn't it, that you are asking Mr. Singhal at this point in time to pay your historic dues owed to you, yes?
I'm following off for paying my historic dues, my remuneration with Mr. Singhal. Yes, and I had similar discussion with Mr. Enzo Vellucci as well. I mentioned that.
And when you refer to your discussions with Mr. Vellucci, you were also aware from an early point in time that he was of the view that those would need to be settled by Mr. Singhal, correct?
Mr. Vellucci had one stand that I'm not the owner. Mr. Singhal had one stand that after the SPA has been signed, and this should be clarified by Unitas to them. So that was the actual, in reality, what was happening. And I was caught in between, and I was trying to get my payment and wages from wherever I can. And this is after the application for change of control and everything had gone in.
So as you just said, you were trying to get your wages from wherever you can, but you knew that Mr. Vellucci's position was that when it came to this apportionment, that he wasn't going to assume that cost. That's what he was telling you, yes?
No. Mr. Vellucci is telling me that my employment is still with BTAML. And BTAML is owned by Sanjeev. But if you go back to the SPA, it says after a certain date is Mr. Vellucci. So I'm going to say Mr. Vellucci has taken a stand and is telling me that doesn't change any fact that my salary was due to the defendant. I was struggling between the previous owner and the new coming owner.
Mr. Gahlowt, your lawyers will be able to make whatever legal submissions they want to. I'm asking you about what you understood Mr. Vellucci's position to have been at this time. My question to you was, based on what you were saying in this email, did you understand Mr. Vellucci was telling you that your historic dues fall to the existing owner, to Mr. Singhal?
No, Mr. Vellucci is saying that I am still not the owner. You can take your salaries and everything about BTML and you speak to Mr. Sanjeev. That's what I'm understanding. He's asking me to follow up with Sanjeev and not with me.
And in fact, in this email, you are following up with Sanjeev. You're coming to him and you're saying, pay my salary, yes?
Yes, I am saying that.
And you say this again at 750, so over the page. At the bottom of this page, you're saying, Dear Sanjeev, I've not received my salary for more than a year now. I've been working in good faith. The delay in the change of control has happened for reasons beyond my control. Now, pausing there, it seems to be your understanding, and you can correct me if I'm wrong, your understanding here seems to be that once the change in control is completed, you're going to get paid in some way, and that the delay wasn't your fault. Yes?
Yes, part of the money that Sanjeev has said that I will have to pay you, I will do it when I'm actually receiving the SPA amount and my capital is free and everything. Yes, so change of control getting approved was one of the incident that could have made Sanjeev pay my past dues, which he had agreed to pay.
Yeah. So you know that Mr. Singh is telling you that when he gets his payment from the change of control, you're going to get your payment out of that amount of money. Yes?
No, he's saying that the amount which is there as a capital in that PTML account, the amount had to come from there. And he had somewhere discussed and demarcated that when the approval is received from the FSA, whatever is the required capital, whatever is the required authorized individuals and everything responsibility will be of Enzo. Before that money that was there in the account, and that's why the segregation mail you would have seen, because in between there were a lot of money that was pumping in by mostly for the operating expenses by Enzo. I had to keep it segregated and ensure that what is going out from whose money. And that capital that was there, when Sanjeev agreed that, okay, fine, you can apportion from whatever is apportioned to me, take that money from that capital amount and release that capital to me. SPA amount, I think it was $100,000, which on negotiation changed to $75,000, which was paid.
So you know that Mr. Vellucci is pouring capital into the company, yes?
Sorry, Mr. Vellucci is?
You knew that Mr. Vellucci was pouring capital into the company.
Yeah, he was making payments because we had to for the operating expenses and everything. He was not meeting everything, and that's why a lot of aged payables were there on the book.
And you knew that at this time, the point when you were going to get paid was from Mr. Singhal when he got his transfer of whatever he was due from the company's account. Yes?
To the extent what Sanjeev had to pay, that doesn't mean that I was not, I'm going to say it was not my dues on the defendant.
Now, if we continue on to 752, again in the same email exchange, this is in March 2022. At the top of the page, he says, "Dear Amitesh, I think the understanding between us is documented, so there's no room for any confusion. Kindly take printouts of the emails and we can discuss in Dubai next week." So he's being quite specific here. He says you've got an understanding. He says it's been documented, and because of that, there can be no room for confusion. Yes?
Yeah, that's what the mail says.
Yeah. And he's even more specific than that. He's asking you to bring printouts of that documented understanding. Now, a printout can only refer to something that's actually recorded in writing, can't it?
Yeah, printout is a printout of the mail that he's referring to. I would like you to, okay, fine, yes, please complete, sorry.
Now, at 753 over the page, you respond, this is the top. "Dear Sanjeev, I will keep the printouts of the discussion and understanding that we had. First discussion was to continue to March 21, and then it was decided to sell the business. The timeline and the various work to be done was discussed or clear. We will discuss when we meet." So you're not resisting his assertion that there are documents which you can get printouts of, are you? You're saying to the contrary, I will keep the printouts. So there is somewhere a written discussion of an arrangement between you that you're both referring to in this exchange, yes?
Okay, I need to give you a background to this. It is saying if we go by the email that I have written March 2021, and I'm following up with him on March 2022. It's a year back. And the discussion is that when the business was being reviewed by various buying parties, and it was not materializing, I was following up with Sanjeev as well with my for my wages and everything. And there was a discussion that, okay, fine, till March, if we don't find, we will have to wind down the business, and I'm okay to support you on that particular thing. In March or probably early April, Enzo started looking and expressed his interest to buy the business. And then things changed, and which is kind of reflective of that. What printout it is there, I don't remember when I had gone, because this discussion is sometimes when Sanjeev had to visit Unitas when we were making the representation to DFSA. That meeting had happened at Unitas's office, and I do not remember carrying any document at that point in time. All the printouts and everything were there in the office, which we had carried to DFSA's office.
Yeah, well,
Unfortunately, yeah, sorry.
A printout would mean a printout of an electronic document, wouldn't it?
Yeah, a printout would mean a printout. Yes, I could have printed out any document that is being asked, but unfortunately, I don't have the access of the email and documents back then.
And to link this to something you say in your second witness statement, so this is page 184 or 199 of the PDF, paragraph 62. This is a reference to something Mr. Vellucci states. He says he does not believe that either Mr. Singhal or I believed that he was responsible for my salary from June 2021. And you say it is accurate that I had understood that Mr. Singhal would pay my salary up to the effective date of the transfer, and that this would be settled outside of the sale. This is why my outstanding salary did not appear in the calculations being circulated between Mr. Singhal and Mr. Vellucci by me, which were prepared to explain how the proceeds of the sale would be distributed, including deducting amounts owed to me from the amount due to Mr. Singhal. So I misspoke. This is your third witness statement. Now,
Yes.
Your reply witness statement is the first time that you put forward any suggestion as to why you didn't include salary in your calculations that we looked at from October 2017. But it seems to be that your case now, at least, is that you came to some kind of side deal with Mr. Singhal.
Sorry, you were asking this question to me, or?
Yeah, that seems to be what you were saying here. You had some kind of side arrangement with Mr. Singhal, which explains why you didn't tell anyone else.
No, Sanjeev, of course, had to make the payment till the effective date, which he had not made. And he took a stand and he represented to me and he said to me that I will treat you in the same way how I treated all the exiting employees who were leaving me. And that's how those calculations were done. Starting from August, when the approval came, it was ratified, and he needed to see those itemized number, and which I showed to him.
Well,
So I'm going to say it was not a side deal or something that I had with him. It was, he was irrespective. He's saying that how you apportion that in your books, it's up to you.
But that is, you said something which is very similar to what you then say at 109 of your second witness statement, page 159. So that's 174. And this is, again, an attempt by you to explain your inclusion of notice pay. You say the reason notice pay is included is he said he would pay me the same amount that he had paid to all other employees with whom he paid notice on termination. Now, we've looked at the email communications from March 2022 between you and Mr. Singhal. We've seen reference in those from both of you to your documented discussions and to the printouts that you had of those discussions. You are presumably aware that in the context of these proceedings, you were asked to produce your documented discussions with Mr. Singhal, yes?
Yes.
And you haven't produced copies of any of those discussions, have you?
I don't have those copies.
And in any case, when it came to it on the 17th of October 2022, when you emailed Mr. Vellucci, what you told him was that the payment he was going to make to Mr. Singhal was after deducting your dues. Yes?
Can you refer to the email in October that I had sent to Mr. Vellucci?
We looked at that document in some detail earlier. You sent an email to Mr. Vellucci. It had a table containing A, B, C of what was paid to Mr. Singhal, and you said this payment will be made after deducting my dues, correct?
Dues from Sanjeev, yes, not from the defendant.
And you didn't provide any further explanation about whatever side deal you'd come to, whatever arrangement, whatever documented understanding you had with Mr. Singhal was to Mr. Vellucci, correct?
To Mr. Vellucci, no, it was always discussed and agreed. I had kept in that meeting, personnel from Unitas was there. My communication with Sanjeev is not a side communication. Unitas people are marked in both of them. That's how the communication ever since when this deal started fructified happened. So if I am clarifying something and if something is not very clear and obvious, anybody can clarify things from anyone. So what I represented and what I clarified has been absolutely clear and consistent, whether it is to Mr. Vellucci, that, okay, when I did all those calculations and I was asking for my dues, when he said that you forget about the past dues, then he said that you take whatever you have to take from Mr. Sanjeev, otherwise I know he will not pay. I said that no, he has already agreed that he will pay what he had to pay. And that's the discussion, how it transpired. And I said that, no, you have to pay this amount. When he disagreed, I had expressed myself that you can please take off my directorship and I can resign it at this point in time. Then people intervened from Unitas and said that, okay, fine, let's calm it down. Let's not derail this particular deal at this point in time. So everybody was making representation. I was not misleading.
Well, we'll come to that in a moment. Now, we've seen you sending Mr. Singhal emails asking him to pay your salary. You haven't exhibited in the context of this case, have you, any communications from either October or November or December 2022 where you're asking Mr. Vellucci why he hasn't paid your salary, have you?
Because that discussion happened in October, and I received part of the payment in November. I started following up with him in December, and he said that, okay, we have agreed, because he said that I will pay $10,000. Nothing was coming way. So I was following up on call, and whenever I was having the discussion with Mr. Vellucci, then in December, when I followed up, he'll say that, okay, we'll speak in January. So I'm going to say how many times I just keep begging like this. And
let me break that point down before I come back to the question. You've now placed this $10,000 discussion in December. Earlier you said it was in October or November. So which one is it?
I'm sorry, it is same. I maintain that stand. That happened in that particular meeting.
Yeah, so this can't have happened on your evidence after you say you were paid the amount of money in the 21st of November 2022. So you're saying the discussion about $10,000, that happened sooner, yes?
Oh, yes. On 21st of November, there was no meeting. The meeting happened before.
Right. So putting it to you again, your evidence is that for this period of time, and in fact going back all the way to March 2021, it was the defendant who was liable to pay all of your past unpaid salary payments. So my question to you was, it's right, isn't it, that there's no record of a communication from October or November or December 2022 where you're asking Mr. Vellucci, why hasn't he paid your salary?
Why hasn't he paid my salary?
Yes.
Because he is outrightly rejecting it. And I am pestering him that, okay, fine, you speak, and there were discussions. We'll have a discussion. It was all agreeing on the books. Yes, to answer your question, yes, there is no email where I have followed up on email to him. I have just have been communicating with reference to the meeting that I had in October, November, leading up to payment that happened. I followed up with him on call in December, and yeah, that's it.
And you've already said,
then followed up in February, March. Yes.
You've already said earlier, it's not like you and Mr. Vellucci were in the same office every day having conversations in person. You weren't in the office, correct?
Sorry, I was?
You've already accepted earlier, during this period of time, you weren't in the office. So it's not like you were seeing Mr. Vellucci in person and having conversations with him in person, correct?
Yeah, it was only the meetings when was organized in person, we used to meet.
Yeah.
There was no office that was there to go and meet. Nobody was attending that. No office.
You haven't provided any evidence, documentary evidence of asking about your salary in January 2023, correct?
About my salary in January 2023.
There's no communication you sent to Mr. Bellucci saying, please pay me my salary for January 2023, correct?
Yeah, I have not sent any communication. Yes.
There's no communication in February 2023, correct?
Yes.
The first time we see you claiming to be owed anything by the defendant is if we go to page 1116. So that's page 1131 of the PDF.
Mr. Doherty, do you mind me asking how much longer you think you're going to be?
I think with a reasonable headwind, I could be finished in 45 minutes, but I'll try and be swift.
May I please impress upon you to try and take even less time? I'm just worried. Otherwise, I'm genuinely, because of the time difference and because unfortunately, due to some misunderstanding, we didn't start earlier. I may in fact suggest that we just take a 5-minute break here. So I can come back.
Your Honour, I don't want to. I know this is going to be the most unpopular intervention of the day, and I think it's probably as well we're having a break. But of course, one issue that has not been discussed at all is re-examination. Now, there were incidents earlier where Mr. Gahlowt said, I want to give an explanation.
Yes.
Both you and Mr. Doherty has pointed out that. Now, I'm going during the break to speak with those instructing me about cutting potential re-examination down as far as I possibly can, but it's not less than 15 minutes. I don't want to
Yes, I was hoping we might be able to conclude cross-examination by 3:45 p.m. UK time so that we could have 15 minutes re-examination. I may have 1 or 2 very short questions. Why don't we just take literally a 2-minute break, come back in 2 minutes, and then let's see how we can progress. Thank you.
Thank you.
Thank you. We can continue. I should just mention I have a cup of coffee here, which I may consume sparingly.
What can I say?
You're on mute.
I say you're on?
Yes.
We're all. I know that all the parties are grateful to you for sitting late. And tomorrow we'll start earlier.
Yes. Yes, I certainly hope so. Thank you. Thank you. Yes, Mr. Doherty.
Thank you. I'll go through these as quickly as I can. We were on the document at page 1116, which is an email chain from the 18th and 19th of March. So that's 1131 of the PDF. And so you can see at the bottom of this, you say, Dear Enzo, with reference to our discussion today on the subject of my resignation from the board and the role of SEO, I would like to tender my resignation. I'm okay to support until the time you find a replacement. In the meantime, request you to pay all of my dues. He says, what dues? You say, those are my salary and benefits per employment contract as banyan tree. And he says, I'm confused. What exactly are you talking about? I gave you an offer in January, which you turned down. Now, you would have understood from Mr. Velici's response, presumably, that he did not consider you were owed any dues at this point in time.
Sorry, I would have understood what. Can you repeat your question, please? You
would have understood from Mr. Velici's response that his view was you weren't owed any dues at this point in time.
My understanding, honestly, was that he was in denial.
When you refer to your salary payable as per your employment contract with Coinvesting, it's right, isn't it, even here, you're not yet talking about past salary benefits prior to November 2022, are you? This just appears to be a reference to an employment contract you say you have with Coinvesting. Yes?
Coinvesting stroke BTAML. So I'm going to say my employment contract is with the same entity.
Well, you don't say in this email that you have accrued employment benefits, including unpaid salary, going all the way back to 2021, do you?
I mean to say, I think I have asked him to pay the dues that is there on the defendant.
You don't say in this email, do you, that you're going to be claiming from the company historic salary payments going back to March 2021, correct?
I don't know. In the meantime, request you to pay all my dues. What does this mean?
Mr. Gahlowt, we've got a relatively limited time. If you could listen clearly to the question that I'm asking and answer that question. In this email, you do not make reference, do you, to the payment of employment dues going back to March 2021?
No, I haven't made specific points that you're talking about right now.
Mr. Doherty, just to see if we can proceed more quickly, if you want to make a point that something is not mentioned in an email and you don't get the answer you're looking for the first time, you can make that in submissions. We can see what's in the emails, what's not in the emails, and we might be able to proceed a little bit more quickly.
Yes, understood. And what you're saying in this email is your resignation, that is from the board and your role as SEO, yes?
Yes.
Okay. So if we could go, please, to page 1133. This is an email from the 30th of March. This is from Amar Azar. It says, Dear Amitesh, please see the attached list of payables as per the accounting records. I understand that Sanjeev has agreed and settled your previous dues. Please let me know the amounts. So on the 30th of March, when you receive that email, do you agree that you would have understood in that point in time Mr. Azar was under the impression that Sanjeev had agreed all of your past payments?
Not all of my past payments. As the line reads as well, Sanjeev has settled your previous dues. Please let me know the amounts. And in response, I give what all payments I have received. And he made those adjustments.
Well, we can look at what you then say at the top of the page. You say the firm has paid USD 45,000 towards due salary. So you have to increase the amount from, and then you provide an explanation for that. Now, we've already looked at the breakdown you had provided back in October 2022, and that was specifically related to end of service gratuity, dues payments, notice pay, and so on, wasn't it?
Yes.
So it is misleading for you in this email to have said that these were payments towards salary. That is not how you had explained it in the past, is it?
That is for Sanjeev, because he wanted to see that, okay, I'm treating you in the same way how I have treated all my employees who were leaving, and how it was to be apportioned on the books, I have explained there. And nobody had any questions at that point in time. So I'm not misrepresenting, I'm just stating as things happen.
This is the first time you've ever suggested to anyone that this is a payment due towards due salary, isn't it?
On email, you might say yes.
Yeah. Go to 1146, which is 1161 of the PDF. This is a calculation of the amount which you land on saying that you're owed. And we've already addressed your earlier emails and whether you ever said that this was a partial payment of a larger amount. But this is, it's right, isn't it, that this is the first time you've notified either Unitas or Mr. Vellucci that you were claiming unpaid salary and other entitlements in excess of $260,000, correct?
Well, I was claiming my past dues all throughout since the discussion started in October, November. When you're talking about this, and at that point in time, salary due was different. As things accrued, it increased. And in March, I had to put everything on paper, tell him that, okay, fine, I do not wish to continue like this. However, I'm not foregoing my past dues. And the calculation is adding up to my total payable amount 263,000, which has been calculated by the finance officer.
Well, let's pause and look at the figures. So this is $263,000. Even if you were to chalk off every instance of salary payment from November onwards, you're still talking about a sum in excess of $200,000, yes?
Yes.
Yep. And you did not previously, in October 2017, when you were communicating with Mr. Vellucci about all of this, you did not tell him that you had unpaid dues, which you were going to claim from the company in excess of $200,000, correct?
Because it was not in 2017, it was not $200,000.
In October 2022 and November 2022,
Yes.
if you look at these sums, if you take off your $12,500 a month for 4 months, you're still going to end up with a sum in the region of $200,000. Yes?
No, I recall the discussion happened sometimes in October. And from my memory, I'm talking about the salary due, inclusive of the previous years, which was, if we can check it in the financial statement, but I'm saying it from my memory, was somewhere around about $200,000. So if that discussion was happening sometimes in October, then with my rough calculation, it will be around $165,000.
All right, well, we've seen the communications. I'm going to put it to you in this way. You would have known if you told Mr. Vellucci in October or November that you were owed $200,000 plus $1,000, there was a risk that he was going to pull out of the deal. Yes?
I don't know, Mr. Vellucci could have pulled out of the deal at any point in time.
And as you put it earlier, you were just trying to get your wages whatever way you could. You would have known that if you had claimed this amount from Mr. Vellucci at the time and he pulled out, it would have left you with nothing.
Why? My claim would still have been on the defendant.
And the defendant wouldn't have had the capital injection that Mr. Vellucci put into the company, which is ultimately what led to your payment in November 2022, correct?
I mean to say, I can't go back and say something what could have happened. Yes, if that's the situation, could have been that funds would be less or I would have been paid what is required. Yes.
What has in fact happened here is that you've allowed Mr. Vellucci to believe, as you put it, that there was a blank slate or he was wiping the slate clean so that you could secure the change in ownership to make sure that you got paid. Yes?
No. It was very clear, all representations. It was not only me who was making representations. If there was any doubt, it could have been clarified from Unitas, from compliance, from whoever he wanted to. I have not made this representation to him or had any intention. It was pushed that, okay, please forget the past dues.
And it's months after you've got that payment in hand that you're coming back for the first time and you're trying to get more. Yes?
Yes, I have put that on a paper in a month's time. Means you're talking about December, January. In January, Mr. Vellucci itself is saying that he made an offer. February, I think I was waiting. I think compliance was not available. And in March, I met him and I said that, okay, I will not continue, but I still want to make my dues to be cleared. Yes, that's what happened.
One of the things you say about this March resignation email chain is that, and this is in your third witness statement in paragraph 85, you say that Mr. Vellucci never responded to your emails to suggest that you weren't an employee of the company. Now, if we look, please, at page 1127, that's 1142 of the internal numbering. And on the 3rd of July, he sends you this email at 12:10 p.m. You can see in the bottom 4 lines, amongst what he says is, you've never worked for us, you've never been one day in our office, worked on behalf of the company, talked to any of our employees. So what you say in your statement is not correct. You must have been aware that Mr. Vellucci did not consider you to have been an employee in the company at this time.
I would say it was Mr. Bellucci's denial, but with everybody's conduct and everything, I have been interacting with Mr. Bellucci being marked on that. So I don't know how he's making this kind of a statement here in this email. You yourself can see.
Yeah, but you knew that was his view. That's the point. So it's not correct what you say in his statement that he never responded to you suggesting you weren't an employee. He has responded to you and he's told you, I don't think you're an employee. Correct?
Yes, that's what he's saying here.
If we go please to 1194, which is 1209. Shortly after the communication we've just looked at, where Mr. Bellucci says, you've never worked for us. And if we go to the bottom of this page, 19th of July, this is an email from Mr. Aslam, and he says, hello, Amitesh, please find the report as amended. If you're happy, let us inform the DFSA that you're exiting. And if we go up to page 1193, you'll see on the 20th of July, he says, hi, Amitesh, can we do this, please? I wish for it to be sent ASAP today. So these communications, these are sent several weeks prior to you providing your own notice of termination on the 11th of August, yes?
That was not a notice of termination. That was my information and indication that I will move out. But I will support you till the time you find my replacement.
Yeah, I'm talking about your 11th of August communication, where you say you're terminating your contract for cause.
Yes.
Yeah, this is several weeks before that. You've got this exchange with Mr. Aslam, where he says, I want to send the notification to the DFSA that we're exiting ASAP. Yes?
Yes. And this report is the quarterly report that we were informing, which was a condition of change of control process where we had to update DFSA. So he's seeking my consent on that.
And if at 1191, he says he's going to send this to the DFSA. I will also complete your IND3 form today and copy and Enzo so we're all on the same page. Now, if you keep that in mind, I want to come to what you say in your witness statement. This is page 170 or 185 of the electronic bundle. Paragraph 15C. You talk about this exchange and you say that Mr. Aslam fails to mention that on the 24th of July, he submitted a quarterly report on which he says that the firm and the present SEO have decided to part ways. The withdrawal forms will be submitted within 7 days of the date on which the SEO ceases to be employed by the firm once that date has been confirmed. So the first question is, Mr. Aslam has told you when he wants to fill out that form, doesn't he? He said he wants to fill it out today. Yes?
Yes.
And if we look at the report that you have referred to, that's at 1200, 1215. So this is, you can read it sideways, but we can, yes, it's been flipped already. If you look under bullet point 1, new employees, do you see there? It makes a reference to Eddie Ambro, new employee to replace Amitesh at the SEO. So you were copied to this report. So you would have known at this point in time, a new individual had been hired to be the SEO, correct?
So you're talking about 24th of July?
Yes.
Yes.
And if we go to 1202, we can see there are a series of deadlines, which refers to both Eddie's application to be appointed SEO and the application to remove you as SEO. And we see the deadline for these is the 30th of July, 2023, correct?
Yes.
And I think one of the points you're making in your witness evidence is that you say, in order to be compliant, within 7 days of termination, you've got to submit this report to the DFSA, correct?
Yes.
So if we go to the supplementary bundle, please, at 189. Where hopefully we'll find an application to vary or withdraw an authorized individual. See that?
Yes.
And over the page, we can see that the submission date is the 7th of August, 2023, yes?
Yes.
And at 191, we can see that this is an application to withdraw you as a licensed director and SEO, correct?
Yes.
So on your own case and on your own analysis of the regulatory requirements, this application would have been filed within 7 days after you were terminated, yes?
After I was terminated.
Yes, that's
I
the
don't,
evidence.
I don't know when I was terminated. There was no agreement till that point in time. I had say that we had to agree on a relieving date. This has been produced to me now. This was never shared with me when this application was made. So how will I know at that point in time when I was resigning that this has already happened? It was never communicated to me.
Well, Mr. Aslam,
If from that report that you're talking about, probably yes, but in fact, it was mentioned there that whenever it is agreed, we will move, but nothing came to me that, okay, fine, your termination is happening on 30th of July and something, no communication to me. So thereby I had to finally resign for a cause on 11th of August.
Yeah, you would accept that this document predates your own 11th of August letter, yes?
Can you scroll up a little bit?
Well, it says we can scroll up if we need to.
Yeah,
We already you confirmed it's the 7th of August.
Okay, so yes, if the date is mentioned 7th of August, yes.
Yeah, I have a few questions just on slightly separate issues to deal with in the submission in the interest of taking a proportionate amount of time. There are a few points of your evidence where you criticize the defendant for not providing you with documents that it should have, and you give examples of all employment contracts and communications in relation to contract matters. Now, first, do you accept that those documents would have been created at a time prior to Mr. Vellucci taking control over the company?
Yes.
For a significant period of time before Mr. Vellucci took control of the company, you were the SEO and senior manager and indeed the only employee of the firm, correct?
Yes.
If we look at page 187 of the supplementary bundle, this is an email from Mr. Aslam to George, Eddie, and Mr. Vellucci on the 7th of August, and you can see it makes reference here. So this is Mr. Aslam saying, we need to have a handover of documents from you. We will need to send a car or van to collect the documents as they are vast. It's correct, isn't it, that you held a significant number of documents belonging to the company, some of which you produced during the course of these proceedings, yes?
So this is a mail from Ishaq to George, yes.
Yeah, and some of those documents remain in your possession, correct?
Yeah, they were, when we had vacated the office, some of the office documents were kept at my residence, and it was with the permission and information to everyone, including the regulators. We had taken a flexi office.
And just to be clear, those documents are still in your possession, correct?
No, I gave it back.
And as well as hard copy documents in your possession, I'm just going to put it to you, you also have retained soft copies of documents belonging to the company, correct?
Well, to give you an answer to that is, I have not retained documents that remained in my place of work from where I worked for a very long period of time, and it was saved. It was, nothing has been not there which was not on my email, and it was as a domain transfer and as an admin transfer, it was transferred to Mr. Bellucci sometimes in end of November 2022. So it is not that I was withholding those documents to not provide him anything. That just remained.
And to be clear, you still possess those documents, yes?
Yes, which we have produced you in the as a document production.
In your second witness statement at page 135, which is 150, at paragraph 28, so there should be page 135. And in the interest of time, I'll read out to you what you say. I think the document will probably follow. But what you say is that the defendant did not amend my employment contract to reflect the changes to my role and responsibilities following my appointment as SEO and senior manager. Now, we looked at the document confirming that appointment earlier. So this is in 2020, correct?
Yes.
And just this is so I can understand your case on this point. Who do you say should have done this?
The HR manager at that point in time?
Well, this is 2020.
Yes.
What follows in 2020, as you're aware, is the COVID pandemic, yes?
Yeah, so this happened in February. By that time, everybody was there. So precisely, you were right. February, March, end of March, we all got the news that our parent company is in deep problem, and there is an administrator that has been appointed. And yes, things followed from there.
Yeah, all of the other staff bar you were terminated, yes?
By July, August, yes.
Yeah, you were the SEO. Why didn't you make arrangements in relation to your own contractual arrangements?
Okay. There was, so I would like to answer this is that on a daily basis, I was not looking at that, okay, what is my contract and what is there in place or not in place. And I'll give you an example of like visa and passports that we have. We don't check on a daily basis what is this expiry and what is there or not. It got picked up during conclusion of the audit, which was sometimes in 2022 for 2021. Sorry, 2020, 2019, which happened much later. It kept on being pending for 2 years. Through conduct and everything, I never realized that my contract is not amended and everything. And I had to amend and give it to it. It just continued.
Right.
Sorry, just let me finish that. By March end, we got a news that our parent company is in problem. All referred clients are in problem. Nobody had any clue how things will shape up, who will stay and all. That was a very, very difficult time. And at that point in time, it was more so to understand the future course of the business, every employee and the clients that were referred, rather than me going and rectifying myself as an SEO, my own contract.
Well, Mr. Gahlowt, this is part of your case, which is why I'm asking you about it. This is part of your case for breach, and you're the only employee, you're the SEO. My question is, who is it? Who else is it you say should have done this?
If it was raised and it was flagged, and if it had to be done, probably between compliance, finance, and myself, we would have done as we were doing all of the work.
Right.
We were a small lean company. We worked
You
like a team. Sorry?
You didn't flag it at the time. I think you've already said that.
Yeah, I mean, it was not, I did not flag it. It just never came to anybody's notice, and nobody noticed it. There was enough of challenges. There was constant discussion with regulators on a fortnightly basis at that point in time, which evolved to monthly and regular updates. So I mean, so the scenario was such that we were not sure how things will shape up with the company.
Yeah. I have two more things to ask you about. They're brief. One, the paragraph 83 of your third witness statement, this is your reply witness statement. You say you refer to another meeting in JLT offices used by Mr. Vellucci. You say that he sought to persuade you to continue indefinitely as the SEO on the basis of agreeing to pay me the same wages you were already entitled to. Again, however, he wanted to wipe the slate clean. Now, you don't refer to that at any point prior to your reply witness statement, correct?
Can you repeat your question? Sorry.
You never refer to that meeting at any point in these proceedings prior to your reply witness statement, correct?
So my earlier reply statement, I have not mentioned that particular point. That's what your question
The
is?
statement,
Yes.
just out of fairness, I think it might be better if we all look at the paragraph that you are referring to and the witness has a chance to look at it before answering.
Yes. It's at page 189. So this is paragraph 83. This is evidence being provided in response to some of the points made about the March 2023 email communications. You refer to a meeting at JLT offices, and the simple point I put to you is that this is the first time in proceedings that you mentioned this meeting.
Yes.
And I'm just going to put the point to you, which is the reason you didn't mention a meeting like this before, in reality, because such a meeting never took place, correct?
No, this meeting took place.
The last document I want to take you to is page 399, which is 414 of the PDF. This is a document from the 16th of October 2018. It's titled Banyan Tree Bank Limited Full and Final Settlement Pay Period ending 16th of October 2018. And at the bottom it says there is a pending claim of 5,400 dirhams. Once the same is approved for payment and the above, and it says 39,190 is paid to me, I confirm that there will not be any dues from Banyan Tree Bank to myself. So when your employment with Banyan Tree Bank Limited ended, you signed a document confirming that you were not owed any further dues, correct?
Yeah, I think yes, this is the document that I signed when the change was happening from BTML, Banyan Tree Bank rep office to BTML. And it is, if you see, it is my monthly basic at that point in time, the leave encashment at that point in time, because I was 4 or 5 months only in the system, so my gratuity was not added and not paid.
All right, thank you. Those are my questions. I think the remainder of what I have can be dealt with in submissions.
Thank you very much. I'm very appreciative.
Okay.
We'll move to re-examination.
Apologies if this is fast. Now, I, in an ideal world, would do a screen share with those instructing me, but I think that I'm just going to have to do it myself in the interest of time. So first of all, can we go to this? Is the screen share working? We should be at the screen that was just being viewed, yes. But if it's illegible. Right. First question, Mr. Gahlowt, arising out of the question immediately asked of you before. Did you sign a document equivalent to this at any later point after you joined the defendant?
No.
Second question, page 983 of the hard copy, and it is page 998 of the PDF. It was put to you that you had never complained about partial payment. Could I ask you to read this email that you sent to Mr. Ali and others on the 19th of December 2022, please?
Dear Ali, as discussed, please find attached the statement for the month of November 2022. The transactions are as follows. Capital infusion by Enzo, amount totaling to AED 2.2 million. Pending dues contribution for Amitesh. Reimbursement of amount paid by Elise towards the admin fee for the lease registration. Part of the pending salary for Amitesh. Payment to BTCal as per the sale purchase agreement. Direct debit for credit card outstanding.
Can I ask you now to please go to page 1170 in the hard copy, which should be 1185 of the PDF. Now, can you help the court and everyone here? So you'll see that there's a date on this letter, correct?
Yes.
Could you explain briefly to the court what this letter is?
So this letter is letter of representation presented by Baker Tilly for co-investing to sign for conclusion of the audit for 2022.
And what was the relevant date for it in terms of what was the audit date, end date?
End date was 31st December 2022, but submission was when this is the last day we had to comply and file the audited financials.
Now, if we go down to the end of this, this document is, I think this is uncontentious. We had this in evidence earlier, you being involved in chaser chains. This document is signed by who?
Mr. Enzo Napoleon Bellucci.
And can we please then go to paragraph 34 here? Please, could you read that out to the court?
We confirm that the end of service benefits as at the reporting date is amounted to USD 12,368, and this is completely owed to the SEO Amitesh Gahlowt of the company.
Final question. You were asked about human resources, and you were asked a separate question about the number of employees in the company. First of all, did the company at any stage have someone who assisted you or worked on human resources?
Yes.
Who was that person?
Her name was Zinia Khan.
Was she, to the best of your knowledge, an employee of the company?
Yes, she was employee of the company.
When was she employed until?
She was employed until July of 2020 with the notice given. So her notice period ended in August 2020. I don't know the precise date. I think 10th or 11th August.
Did she ever action or suggest to you that your employment contract should be amended?
No.
Did she ever suggest to you that this contract should or should not be renewed?
No.
I have no further questions. I think, Your Honour, you may be on mute.
Thank you. I just had a couple of questions. I know, Mr. Gahlowt, you wanted to explain when you were being asked questions about the correspondence in October and November 2022 that I believe was entitled End of Service. end of service settlement, something like that, and the calculations, you wanted to explain something in the background. Could you, I'm giving you an opportunity now, if you could very briefly offer whatever explanation it was that you wanted to make.
So, Your Honor, the approval from DFSA was received in July, 5th of July. And then the correspondence, and the emails are exhibited, and I think full trail is there, started happening with both Mr. Sanjeev Singhal, who was the seller, and Mr. Enzo. And we had to reach to conclude this sale. This was August, and Sanjeev wanted a clarity in terms of flow of funds and how the funds will move and when will he get the SPA amount due and when he can take the capital that is due. In all those discussions, there were due amount that were to be paid, and the discussion happened that, okay, from the SPA when it is signed, the apportionment has to happen after the effectiveness of the SPA. You have to speak to Enzo for those amount. Anything prior to that, as I had agreed, will be paid to you. I said that I don't want to be doing this. If you have to be clarified, you have to get involved and clarify all these things. He said that it can be clarified by Unitas because that's the understanding. And based on that only, we had agreed on the SPA. Because if this was not agreed, I would have initiated the wind down process, the company. That was Mr. Singhal's stand and version. And then there were many conditions to be met as per the approval. One of the conditions was that Enzo puts in $2 million of capital, as he had indicated in change of control and everything. So that separate discussion started happening that how it will happen. Enzo was not very comfortable and sure because he was not on the bank account and everything. And thereby those board resolution and everything started coming in effect that he can be appointed as director from immediate effect. And I think we have seen those board resolution dated October of 2021. And subsequently things started happening in my discussion started happening with Mr. Sanjeev. He said that, okay, how I have treated all the employees, I will treat you like that. Please show me all the calculation that has been done. If you see the calculation that was happened or the calculator that was used to terminate all ex-employees, I use the same calculator to just itemize the item. It was never intended or understood by anyone that by me doing those calculation, my employment is terminating. It was nobody's understanding. It was just to give him a perspective how much he's paying and how much will be apportioned from the capital amount that is there, which is kind of marked to him. So August, September, and we started having discussion in October. In between, Enzo was having discussion that I don't have 2 million to put in now. It is an old story and everything. And there was suggestion of that we will put in a loan agreement in lieu of share capital, and that will come into effect. But before that, he has to get into the bank account as the board of director and everything. And eventually it was shared. And then we had a meeting that how things will phase out, how much money that he has to put in, when will he get into the bank account and what are the steps on that, what resolution has to be taken in place and everything. And then what capital requirement in that very categorically, all the age tables, including my salary, was discussed with him. And at that moment, for the first time, to my surprise, it was like, forget about the past dues. Take whatever you have to take from Sanjeev, or else he will not pay you anything. And I said that he has already agreed that he will pay what he has agreed to pay and ask for the SPA. But nothing is formalized. And when he was pushing through that, forget about the past dues, I said that if that's the stand, then I would immediately like to resign. You can take off my directorship. And then at that point in time, Sagir Mohammed intervened. He said that, guys, it will look very bad in front of the DFSA. We have reached to this particular stage. We have been in these kind of a situation back and forth with that. We have come a long way. let's try to conclude these documents and everything. And at that point in time, Enzo backed off and he said that, okay, fine, I will pay you $8,000. I said, forget it. I would say, there's no point of discussing all these things. You are enhancing my role as a director. When I became an SEO, I continued on my salary of when I joined as a relationship manager. So with the risk involved and the severity of this particular role, I'm not ready to work for that kind of amount, what you're talking about. And then he said, okay, fine, I will pay you $10,000. I did not argue at that point in time anything, but nothing was agreed. And eventually nothing came through, neither $10,000 nor any amount. But I continued completing the transaction because I wanted to bring the company to its stage. Because I was also responsible for the regulators. I took that seriously. And then eventually I had made up my mind that I will communicate to him that he needs to find a solution. I will not be able to continue if he doesn't make good my past dues. Having said that, I was not adamant on a particular amount. His stand was that I will not pay you anything. And there were many discussions and everything. It kept on happening. And then finally in March, I formally informed that I will move out, but I will support you till the time it is there. But I bring it now in writing that please pay my dues. And things followed. And here I'm with my claim.
Thank you. And just, I'd be grateful if somebody could please screen share the trial bundle PDF number, PDF page number 934.
Is that right? Is that screen sharing?
Yes, I think that's correct. Could we scroll up a little bit, please? Yes. So, Mr. Gahlowt, I just want to ask you, I think, could you again explain, I didn't follow this, why in this table there's an amount of $7,500 included for work done on the withdrawal notice? Why was that not included as part of your
salary?
Work,
or
yes.
Work. So this was suggested to me by Sanjeev himself at that point in time. We were having this discussion sometimes in October when I had shared the emails with him. When the work was being done, when the withdrawal notice was served to us in February of 2022, if I'm right, we had informed Enzo, and Enzo was also very disgruntled that I'm paying this and this has happened now. So at that point in time, the operating expenses of the company were paid by Sanjeev it was still going from BTML account, but from the capital that Sanjeev was holding in from there, with an understanding that if the withdrawal notice is reversed, Enzo will reimburse those amount. And at that point in time, I requested Sanjeev that, okay, fine, you saying that I have to take Enzo. Enzo is not paying anything right now. I need money because I needed money. So he said that, okay, fine, you take this amount on a withdrawal notice. So I just grabbed whatever I could.
Okay. And why did you include 1 month notice pay in this calculation?
Because all the past employees, when the treatment was happened, I think there was one thing shown there. It was in the similar manner. So they were paid 1 month. So it was requested by Sanjeev that do your calculation in the same way, like we have done it for all past employees, and thereby it was included.
Okay, thank you. That's very helpful. Your evidence is now concluded, and so you're free to go. and you're no longer under any embargo not to discuss evidence with anyone. So thank you very much indeed. I think we'll now adjourn for today, and we will start at 8 a.m. UK time tomorrow, which is 11 a.m. UAE time. Again, I'm just slightly concerned in case our existing links don't work. They should do, but could I please request everybody to log on 5 minutes before the time of the hearing starting, just to make sure that we all have links that work, and we can get going promptly at the start time. Is there anything else before we conclude today?
And safe to say, I'm arranging to have that consultation paper sent to the registry so that you can get it.
Thank you. That's kind of you. Thank you very much. I'll see you all tomorrow. Thank you very much indeed.
Thank you.